begin. Remember to speak into the microphone, as this meeting is being recorded for public record. Please take your seats. The meeting is about to begin. Remember to speak into the microphone, as this meeting is being recorded for public record. Please stand by. We are going on air in 5, 4, 3, 2, 1.
Okay, good morning, everybody, and welcome back. Hope everyone had a good August. Welcome to the September 24 Planning Board meeting. We have a lot of continuances today, but we will start with, if I could get a motion to approve the minutes from the last meeting, the after action report.
Motion to approve?
Can I get a second?
Hang on one second. I did notice one correction which
Okay.
we made. Need to go find it.
You mean something that needs correcting?
Yes. Well, I
Okay.
don't have it in front of me, but one of the items it said it said, or I opposed one of the items, and it said 6-0 for the narrative. It may have been the RPS 4 height incentives. I'm sorry. No, it's PB 24-0669.
Okay, and you were a no?
I was a no.
Okay, so can we change the minutes to reflect this, a 5-1 vote?
Sure, yes, I'll correct that.
Or
Thank
it
you.
may have been 6-1.
Should've been
It was
6-1,
just
yes.
6-1.
I'm sorry,
Yeah,
6-1.
Put the one.
Yep.
You need that a 1.
Thank you.
Okay,
And I'll
do
second
that.
it then.
Okay, with that correction, we have a second. All in favor?
Aye.
All opposed? Okay, that's approved. I will turn it over to the city attorney.
Good morning, Mr. Chairman and members of the board. Today's meeting of the Planning Board will be conducted in a hybrid format with board members physically present in the commission chambers at Miami Beach City Hall and applicant staff and members of the public appearing either in person or virtually via Zoom. In order to participate virtually in today's meeting, the public may dial 1-877-853-5257 and enter the webinar ID, which is 861-4342-6327#, or log into the Zoom app and enter the webinar ID, which is 861-4342-6327. Anyone wishing to speak on an item must click the raise hand icon in the Zoom app or dial *9 if you're participating by phone. If you're appearing on behalf of a business, a corporation, or another person, you need to register as a lobbyist with the city clerk's office. If you haven't registered yet, you should register before you speak to the board. You don't have to register as a lobbyist if you're speaking only on behalf of yourself and not any other party, or if you're testifying as an expert witness providing only scientific, technical, or other specialized information or testimony in this public meeting, or if you're appearing as a representative of a neighborhood association without any compensation or reimbursement for your appearance, to express support of or opposition to any item. Expert witnesses and representatives of neighborhood associations shall, prior to appearing, disclose in writing to the city clerk their name, address, and the principal on whose behalf they're communicating. If you're an architect, attorney, or employee representing an applicant or an objector, you must register as a lobbyist. These rules apply whether you're appearing in favor of or against an item, or encouraging or arguing against its passage, defeat, modification, or continuance. Lastly, I'd like to swear in any members of the public and any staff who will be testifying today. Please raise your right hands. Do you swear or affirm that the testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth? Thank you.
Thank you, Nick. Okay, we'll start with all the requests for continuances. The first one is filed Planning Board 240650, Development Regulations Creating the Normandy Isle Overlay District.
We can take the first two items together, which are related. This is PB 24-0650, the development regulations creating the Normandy Isles Overlay District, and the companion ordinance, which is PB 24-0651, the Workforce Housing Comprehensive Plan Amendment. I believe the applicant is requesting this to be continued to the October meeting.
Okay,
We can do November.
so are we
November.
doing,
Yeah, we can continue to November.
Thank you.
More time. Yeah. October's quite heavy and we're not going to be ready.
okay, all in favor?
Aye.
Who made
Anyone
the
opposed?
motion on that for the continuance?
Motion to approve the continuance
Okay.
to the November meeting.
Second.
Okay, we have a second, all in favor?
This is for both items. All in favor?
Anyone opposed? Okay, so it's item 2 and 3, correct?
Correct.
Okay,
Thank you.
all right, see you in October. Next one is
November.
November, I'm sorry. Planning Board File 230609, 1750 Alton Road, Palomar Hotel.
I believe the applicant is now requesting a continuance to the November meeting.
That's correct. Good morning, Mr. Chair, members of the board. This is for the Palomar Hotel, 1750 Alton. When we first applied for this, our client had a prior restaurant tenant. The idea is for the restaurant to expand to service the rooftop. That restaurant tenant, as most of you know, Marini, is no longer with the hotel. They're on the verge, we thought it would have happened already, they were on the verge of signing a incredibly top restaurant from New York to the space that will also operate the rooftop. That contract is not finalized. And while it may be finalized this week, in an abundance of caution, we told Michael we'd like to continue to November. By then, we'll have the restaurant in place, operation plan, everything ready for you with the new operator.
Okay?
Before we take a motion on that continuance request, if we can just see if anybody has any public comment on the motion for continuance?
Anyone on Zoom?
There's no one on Zoom with their hand raised?
Okay, can I get a motion?
Motion to approve?
Second, all in favor? Anyone opposed? Okay. Next one, Planning Board File 220539-660 Washington Avenue Anglers Hotel.
I believe the applicant's requesting a continuance to the October meeting or November?
October, but if it's too packed, we can do November. I think we will be ready for that one. Again, Mickey
I
Marrero,
would suggest maybe November, since we do have a heavy agenda now with all the continuance requests.
understood, and
to
that's
November.
fine.
And that'd be the November
And I
26th meeting.
strongly encourage you to get community reach out.
So
on
that's,
the
and that's
site.
why we're asking,
Okay.
Mr. Chair. So again, Mickey Marrero, 200 South Biscayne Boulevard, here on behalf of the anglers. So in subsequent to the July meeting, the general manager and our staff had multiple meetings with neighborhood stakeholders. One of the things requested was a sound study to be done, in addition to the one that was submitted, actually directed to their residences. Again, this is going to be a much lower scale sound than what we've seen in that neighborhood. So we've had to retain a sound consultant. It's taken a little longer than we'd hoped to get all that sorted out. They still haven't done the testing. So we,
Yeah, and I just want to point out, I know who the operator is, and he's fabulous. I just want to make sure you get community outreach and educate them who it is, because, all these issues now are, okay.
absolutely.
And we do have some public comment on this item. Johan Moore?
On the continuance?
Yes.
Okay, Johan?
Yes, good morning, board members and staff. I actually attended an event, a fundraising event last night at the Anglers, and I can only say that the community, I think, feels very supported by the Anglers, but that is not the question for the neighborhood. I was there scoping out the, the speakers on the wall, and I noticed that they all face west and that there are signs of the east-facing speakers having been removed. Now, since what's across the street are, I believe, the rooms of the Good Time Hotel, that makes me suspicious that even these rather small speakers there do not, in fact, convey noise into adjacent properties. I understand there is a request to defer this till later in the season. I think the neighbors are not opposed to that if, in fact, our voices and more directly, the more immediate neighbors' voices will be heard. I also heard from a neighbor who lives in the front unit on Jefferson Avenue, again, not directly related to the Anglers, that he has, in fact, in the past, heard noise from the Good Time. I urge the conversation to continue with the commission to, in fact, institute a ban on all future rooftop entertainment CUPs, certainly in the areas of town where we're trying to incentivize residential. I'll leave my comments at that. Thank you very much.
Thank you. Anybody else on Zoom?
There's nobody else on Zoom.
Anybody in chambers speak on this? Okay, can I get a motion to continue it to November, we said?
November 26th.
Motion to continue to the November meeting?
Second, someone?
I'll second.
Okay, all in favor? Aye. Anyone opposed? Okay,
Thank you.
thank you. See you in November. Next item, Planning Board File 240670, 220519, and 160008, and 2136 4041 Collins Avenue Hotel.
And this application is for a modification to a prior CUP, which included a neighborhood impact establishment. The city is still addressing, or the applicant's still addressing some transportation comments. So we're requesting that the application be continued to the October 29th meeting.
Okay, anyone on Zoom?
There's nobody on Zoom. Do we
Anybody in
have- Is
chambers
the
on
applicant
this?
here would like to speak on the application?
Okay,
The
can I
applicant's
get,
not here, so
and what's the,
Motion to
when are we
approve.
moving it to? November as well?
to October 29th.
October, okay, can I get a motion?
Motion to approve?
Okay, all in favor? Aye. Anyone opposed? Okay, passes. Next one, Planning Board File 240661, Commercial Industrial Residential Height and Setback Regulation Modification citywide.
And we can actually take, the next two items are companion items as well.
7
Which
and
is-
8.
7 and 8, PB 24-0661 and PB 24-0695.
Okay.
The commission sponsor is requesting that these items be continued. I'm sorry. Number 7 is not related to number 8.
I didn't think
That's-
so.
yeah.
Okay.
So that's separate, yeah, sorry, I got confused. So, yeah, PB 24-0661 is for commercial, industrial, and residential height and setback regulations citywide. The commission sponsor is requesting a continuance of that to the October 29th meeting.
What's the reason for the continuance?
He's looking at additional updates to that, so that's why it's been continued for some time now.
Okay, anyone on Zoom?
Well, one more question as well. Can you share with us what this item is? It doesn't even have, in our packet didn't have
Yeah,
a
so,
description.
at the beginning of the year, maybe, I'm not sure when you were, put on the planning board, Matthew, but at the beginning of the year, the planning board recommended effectively downzoning the height for, the South Beach area, south of 23rd Street. And then the city commission and the land use committee was looking at, amending the height regulations north of that area. So this ordinance would amend the height and setback regulations for areas north of 23rd Street.
Thank you.
Anyone on Zoom?
There's nobody on Zoom. with their
Anybody
hand
in
raised?
chambers to speak on this? Okay, can I get a motion?
Motion to approve the continuance.
Second.
Okay, all in favor?
Aye.
Anyone opposed? Okay. 7-0. Next one, number 8, Planning Board File 240695, Washington Avenue Residential Use Incentive.
Yeah, so, the next two items are related, which
and
is
9,
PB 24-0695 and PB 24-0696. The commission sponsor is requesting a continuance to the October meeting to make some further amendments, to the ordinances.
Okay, anyone on Zoom?
Actually, yeah, we have, one person with their hand raised, Johan Moore.
Yes, good morning again. I'll keep my comments very brief. The only objections to the proposed residential incentivization are in fact excess height. I had a conversation with Albatare of Homelessness Services last night, who is fully supportive of the proposal in general, and as is the community. And I hear that there may be some ideas out there for reducing that height, and we hope that everyone will explore those. Thank you.
Okay, Johan, just so you know, this is a continuance, so, it'll be moved to, it looks like, October. So any substantive comments you'll want to make at that hearing, okay?
Thank you very much. I will. Thank you.
Yeah, anyone in chambers? Okay, can I get a motion to?
Motion to approve?
This is both of them, right?
Correct, both of them.
Okay. Can I get a second? Second, Melissa, all in favor?
Hang on, Mr. Chair. I want to make one comment, though, myself on this one. I was actually surprised to see that it was continued, considering that it was heard at land use, that there was a public meeting as well. But I think this is a good idea, and one comment that I'll make, since you mentioned about perhaps adjustments to the height, because there are no parking requirements, in fact, it seems like there are parking maximums, the actual volume needed perhaps to satisfy the increased FAR won't require such great heights. So I hope that the sponsor or staff may be listening to these comments, and they'll take that into consideration in their analysis that 100 feet may not be necessary for the contemplated FAR, considering those stipulations to that incentive. Thank you.
Okay.
Okay, we
So
need,
did everybody vote on that? All in favor? Okay, thank you.
And by the way, part of the reason the sponsor is requesting the continuance is because there's going to be a special land use committee meeting to review all of these residential incentives that various commissioners are sponsoring, and this is one of them.
But to that point, Nick, I attended the land use meeting last month, or I guess earlier this month, and I didn't speak on the item because I knew it was coming to planning board. But I thought the sponsor asked that this item, since it already was heard at land use, didn't he ask that it basically not go to that special meeting?
I don't remember that, but
Okay.
I know that it's going to be discussed at
is
the
going to
special
be.
meeting. Yeah.
Okay.
It's going back to land use.
But it was heard previously at
Yes.
land use.
Yes, but it's
Thank you.
not complete.
Okay, item 10, Planning Board File 240662, conditional use regulations for grocery and convenience stores in CD3 zoning on Lincoln Road.
And the applicant's here is requesting a continuance to the October meeting, Neeson?
Yes, and the October meeting. Neeson Kazan representing the applicant. Would like to be back in October. We expect to have full neighborhood support as well. Thank you.
Neeson,
Okay,
who's the applicant?
The applicant, it's 420 Lincoln Road, adjacent properties, Ambassador Paul Sejas. is
Where the
owner of
timeout
properties.
market was, right?
Well, it's actually the entirety of the 400 block.
Right. Okay.
Ambassador Sejas owns from Lincoln Road to 16th, from Drexel to Washington.
And what do they want to do?
What we want to do is be able to have grocery stores as a use in that, on that block, particularly to serve the needs of residents as well. So that's the main thought behind it.
And like, what's their intention? Is it, I guess, what would go in there ideally for them?
Excuse me?
What would ideally go in there for them?
You know, we don't have a specific tenant in mind, but ideally would probably be a high-end grocer,
Such as, pick one from
such as
the universe.
Dean and DeLuca's out of New York, let's say, something like that, which would be very, good addition to the neighborhood and to the.
Is that a possibility?
It could be.
Don't take that as an actual lead, but I know that there are some who have expressed interest. They have some very big spaces, not to get into the details of this because we're only on a continuance. But the building, which was built in 1939, has enormous floor plates. And then there's also where the timeout market space was. And those of you, I don't think anyone in this room is old enough to remember this, but there was a Woolworth that occupied most of the ground floor at 420 Lincoln. So the building was like designed for these very large spaces. So it's actually an appropriate place to accommodate uses like this, which are also very much needed in the neighborhood and the street.
And Nisa, let me just say that it is important to get community input because I'm a block away from there, and I hear a lot of people complain that since Art Deco Market is not there anymore, they're looking for a grocery. Not so much a high-end, but just for everyday necessities. So, if that comes in, I don't, at least from my point of view, I don't think you'd have a problem getting an approval. But I'm sure you're looking around, and hopefully something good will go there that'll serve the entire neighborhood.
Yes, that's the intention. Thank you. We'll see you in October.
All right, anyone on Zoom to speak on this?
There's nobody on Zoom with their hand raised.
Anyone else in chambers? Okay.
Good morning, Chair. My name is Annabelle Yopes. I'm the Executive Director at the Lincoln Road Bid. I just want to say we are going to be working with the landlord on this because the board itself is really vehemently against a grocery store on Lincoln Road or anywhere in the vicinity. So we will be meeting with them on our board meeting in October prior to the next meeting. So we just wanted you to know that grocery store is not something we would like to see on Lincoln Road or on Drexel.
Okay, I appreciate that, and again, this is continued, so you'll want to make any
Absolutely.
substantive
I
comments.
just wanted
at
to
the
let
next
you
hearing.
know our opinion as well as
Thank
the
you.
board. Thank
I
you.
appreciate that. Anybody else? Okay, can we get a motion to continue it?
Motion to continue?
Second.
Okay, all in favor? Anyone opposed? Okay.
Can we take a lunch break?
All right, on to actual items, previously continued items. The first is revocation modification hearing, Planning Board File 240678, the Mondrian Hotel.
So this is a public hearing to consider the revocation, modification, or imposition of additional or supplemental conditions to a previously issued conditional use permit for a neighborhood impact establishment. Now, in terms of the history of the present case before the board, on March 28th of this year, the planning department sent a clear letter to the applicant, 1100 West Investments LLC, in response to nine noise complaints that were received for the pool area between March of this year January 1st and March 24th of this year. The applicant was advised that a progress report would be scheduled for the April 25th meeting. On April 25th of this year, the applicant appeared before the board for a progress report, and the board scheduled a revocation modification hearing for June 25th. On June 25th, the applicant appeared before the board, and there were some outstanding code cases that were pending before the special master. Because of that, the board continued the revocation modification hearing to a date certain of today in order to get the outcome of the special master case. As noted in our report, unless associated with an approved special event permit, entertainment, which includes but is not limited to DJs, as well as music played at a volume that interferes with normal conversation, is prohibited. We noted in our report some flagrant violations of the CUP, and these were the ones that were appealed to the special magistrate. On April 6th, a violation was issued for having a live band without a special events permit. Condition 7J of the CUP prohibits the use of percussion instruments, which were part of the live band. On April 27th of this year, a violation was issued for the presence of a DJ on the property, also without a special event permit. Now, these cases were heard by the special magistrate on September 5th of this year, and the special magistrate did dismiss both cases due to technicalities. These are further detailed on page 10 and 11 of the staff report. I'll just summarize the technical issues. So when the CUP was issued initially to the applicant, it was on October 28th of 2008. There have been several changes to that CUP, since that time. When the violations were issued earlier this year, the CUP file number that was referenced on the violation was the one dated on February 25th of 2014, not the current CUP. So that CUP back in 2014 was issued to 1100 West Properties LLC, and the applicant argued that that CUP did not apply to them as it did not reflect their entity, which is 1100 West Investments LLC. Although the CUP was modified on August 23rd, 2016 to reflect this change in owner-operator, the special magistrate agreed that with the applicant, that the more recent CUP should have been reflected in the writing of the violation. The second technicality is that the code sections referenced in the violation were based upon the prior land development regulations. As you know, we adopted a new resiliency code about June of last year, and so although the substance of the code did not change, the numbers changed. So the applicant argued that the code references were incorrect, and the special magistrate dismissed the violations for that reason. Staff did argue with the special magistrate to indicate that the substance of the code had not changed, and that the actual CUP conditions also did not change, and the conditions were the same from 2014 to 2016, just the ownership had changed. So we are recommending today that in order to make it crystal clear in the CUP, that the board at least modify the CUP today to update the reference code sections. Currently, the CUP has all the prior code sections, so we're recommending that the board update the CUP with correct code sections. We're also recommending that the board discuss the substance of the violation. The applicant didn't argue the substance of the violation. The special magistrate was all based upon technicalities. We are recommending that the board discuss it, including modifications as I mentioned, and we're recommending that the board continue this revocation modification hearing to the November 26th meeting. Well, I'll turn it over to the applicant.
Okay. Good morning, Mr. Chair, honorable board members, city staff, and board attorney. James Rao with Greenspoon Martyr, Office of 600 Brickell Avenue, here today with my associate, Adrian Noto, and also some ownership representatives of the hotel and the hotel's general manager. Unfortunately, the principals, owners couldn't be here today, but there are representatives here to the extent the board has any questions. A few things. I try to keep this as short as possible and focus on the positive. But I do have a brief statement to read into the record regarding some legal issues. I'll just start with that, and then I'll explain the rest of our short presentation. This proceeding is based on 9 alleged noise complaints, which were all deemed invalid by the city's code compliance department, as recited in the staff, planning staff's cure letter. There are no violations of record as a matter of law. As you saw in the staff report, the special magistrate dismissed the only 2 violations that were issued. And in those cases, the city did put on its case in chief, and the special magistrate dismissed. So there was substantive discussion. All that being said, the hotel has not wavered in its efforts to maintain compliance with the CUP since we've been here last. They've obviously supervised their staff in a way to ensure their strict compliance with the CUP. There hasn't even been a complaint, let alone a violation, since May. In addition, they've engaged in some neighborhood outreach. My associate's going to hand out some emails of support that were submitted to the city clerk. They were mentioned at the last hearing, but the board wasn't provided with copies. In addition, they recently had a gathering. They invited the neighboring residents over to the hotel. They had about 75 people there. The general manager is here today and can explain to you what that was. And so far, they haven't received any complaints. I also noticed that there is doesn't appear to be anyone here in the public today to speak against the hotel. So, and there's no public comment, no new public comment on the record, except for we're handing out these email letters of support. But there's no public comment in the record in objection. In addition, we heard the board's comments and questions at the last hearing. So the applicant has and further engaged their sound consultant to submit a revised report. And to give you, the sound consultant is here. It's actually 2 representatives from the sound consultant here. To give you a brief understanding of that, they went through and revised what they looked at previously. Some of the board members had questions about some of the language in that report and what it did to confirm that the hotel's in compliance with CUP. So this is a second supplemental report since this hearing started. In addition, what they did was put out some long-term measurement data for about 5 days, just to measure the sound in the area and anything that comes from the hotel. And again, the sound consultant can give you the details on that, but in short, what they determined was that the sound coming from the hotel never rose above a level that would interfere with normal conversation, which is the standard the staff is telling you the hotel has to abide by. 1 second. With regard to the suggested modification by the staff, I think this board's process has worked for what it's designed for. You had some complaints. They were addressed. The hotel is in compliance with the CUP. The record reflects there's no violations, and they maintain compliance with the CUP. And so we're asking that you terminate this hearing today. We don't think there's any need to modify the CUP, nor do we think there's any evidence in the record to support a modification of the CUP. It's a very detailed order. It's worked for many years. This is probably one of the oldest CUPs from 2008. Right now, based on what's before you, there doesn't appear to be any current problems. And we're here to answer any questions, of course. If in the future there would be a problem, you always have a right to call the applicant back. You saw in this case, we're called back here and been to 2 or 3 hearings over 9 noise complaints. So the board doesn't lose anything by not modifying the CUP and ending this hearing today. And naturally, you've sent a very clear message to the hotel. They will remain vigilant, and despite what happens with violations or any other proceedings, we haven't changed our plan in terms of responding to the board and maintaining compliance. They proceeded with updates to their sound report. They continued to manage the hotel in a way that's compliant. So we're asking that the board close this matter out today due to the fact that there's no violations. There doesn't appear to be a problem as we sit here today. And we remain available to answer any questions.
Okay, Michael, real quick, the recommendation to modify, can you go through that one more time, what you're?
Yeah, so we're recommending the original CUP includes reference to the code sections that were in place at the time the CUP was adopted. So we're recommending that those code sections be updated to reflect the current code sections.
Right, why would you be opposed to simply updating it to reflect the current code sections? Like, how is that detrimental to you?
Well, quite simply, I don't think it's necessary. We've never suggested the code sections in the CUP are not valid. I don't think there's anything wrong with them.
Okay, well, let me ask Michael then, what will that do to their current
It'll-
CUP?
No, it'll just reference, so in case this does become before the special magistrate again, we have the correct code sections in the CUP, so that's not used as an argument for,
All right,
for
so
having the
simply
case.
bringing it up to the current code.
Right.
All right,
Yeah,
okay.
and just to be clear, we've never made that argument that there's anything in the CUP that's not valid. And also, just to note, there are more changes in the draft order than just changes to the code sections. There are substantive changes, so, you know.
Where are those, Michael?
I'm sorry, what was that again?
He's saying there's more than just
Well,
that.
We are recommending that, so we did recommend, especially when, we do this whenever we have a case where there's been a progress report or a ratification modification hearing attached. So you know, recently, whenever the board, a change of name or ownership comes before the board, older applications required applicant come before the board
Right.
for that change of ownership operator. And at the time, typically, the board modifies the condition saying you can just submit an affidavit. When we have an issue with an operator that has had violations, we're recommending that condition be modified to actually require them to make an application to come before the board for a change of ownership operator and not just do the standard affidavit. So that's one thing we're recommending
Okay.
that this be modified.
Anything else?
I think that's the only
So
substantive.
what
Well,
substantive?
two
are you-
things,
Huh?
a couple of things. Number one, with regard to that issue, right now, the CUP says subsequent operators have to appear before the board. What staff is suggesting is that condition be changed so that you have to file a public hearing application and go to a formal hearing.
And I think you're doing that with all,
No,
We're doing it.
every other hotel, they suggest a condition that says if there's a change of more than a certain percentage interest, they have to sign an affidavit confirming they're gonna comply with the conditions and then appear before the board after that, for a progress report, which is not a problem, but that's essentially what it says now. They have to, if someone was to buy the hotel, they have to comply with the conditions and they have to appear before the progress report. The change is, now you have to file a public hearing where the board gets put in a position where it has to vote on whether a real estate transaction can occur. That was kind of the whole purpose of this affidavit condition, was to avoid creating that scenario. And again, this board doesn't lose any jurisdiction over anything with the way it is now, or the affidavit condition. Changing it in the manner that it's changed is essentially a punitive measure.
well, first of all, do you have a response to that? Because then I have a question.
Well, I think especially because there's been a history of violations here, that's why we're recommending that this come before the board in advance before just submitting an
You mean
affidavit.
If there's a change in ownership.
Right.
Right, but he's got a point that, like, I understand the policy behind it, but, I mean, does this board have the ability to block a sale of
No, and that's not, and that, you know, the practice of this board for decades has been that the board has to approve a change in owner or operator. But the conditions of your orders run with the land, and the applicant is subject to the conditions of this order regardless of who the
Correct,
entity
and a
is.
new
So that-
owner
so
would be
the-
subject to it as well.
Right, so
Right.
the practice of requiring a new owner or operator to come before the board is to give the board the opportunity to hear from a new owner or operator, have the owner or operator, you know, state on the record that they're, you know, going to be complying with the order, and also to present any changes to the operation that they may be proposing. But there's no question, let there be no question that the conditions of the order run with the land.
Right, I understand that, but I
Agreed.
guess what I'm trying to think out loud is if they're not making changes and it's just simply a change of ownership, wouldn't an affidavit testifying under oath that they will adhere to the conditions satisfy that requirement? I get it if they want to change the operation, but I'm not sure I understand, because then really we could be voting on whether the sale should be approved or not. like a real estate transaction. He's right about that. Am I missing something?
It's not going to vote to approve the transaction. So right now, the way the
Well,
process
we're
works.
voting on a change of ownership, right?
So we can approve that in advance. So let's say that the board changes this application to require a new operator to come before the board. As part of a new certificate of use application, before we can approve with the city the change of the ownership operator, the applicant would have to at least file the application before the planning board. So as long as they file the application, pay the fees, have it scheduled before the board,
Right.
then the city can will approve the change. But it's sort of to force them to come before the board. The board can ask any questions of the applicant. We can also look at the history of violations at that time and make sure that, and the
I
board.
get all that, but what would we actually be voting on then? No? Like seriously, I wanna know what
You're
is
voting,
that-
what you're doing is you're voting on conforming the order to whomever the current owner or
Okay, all
operator
right.
is. That's
So
what you're voting on.
we can't reject the proposed owner.
Let me give you the practical side.
Well,
of that.
sorry.
I
Before
think,
you- wait,
yeah,
one
just
second.
to reiterate, I mean, this was the practice, right? Was that the board voted on any change owner operator. We only changed that in the interest of efficiency, since the board's dockets were heavy, and also it creates a hurdle for certain applicants. But in this case, staff is telling you that because there have been issues with this property, that the board may want the opportunity to hear from a new owner or operator. Now, it's your call whether you want to include that condition or not, but that's.
No, I get that, but that's not what I'm asking. I'm asking, what would we be voting on then? Because it can't be that we can reject the new owner. I can't imagine we can do that. So what would we be voting on if they came back with a proposed new owner? Just saying, please conform to the CUP, right?
Yeah, you're voting on conforming the CUP to the change in owner and operator, and you're also, you also have the opportunity to hear from and potentially impose
That I
additional
get.
conditions.
I get we can hear what they want to do with the property. Again, I'm just asking, what would we actually be voting on in that scenario?
I mean, I'm not going to say anything now that's going to limit you on a future application. So I think if someone's before you on a change in owner operator, you, depending on the circumstances, may have, the ability to make other changes.
All right.
Mr. Chair, if I might just have 10 seconds.
What's that?
If I might just have 10 seconds to explain
Sure.
the practical problem.
And then we're going to open it to the public. Go ahead.
Well, number one, there's no history of violations in this property, so there have been issues. That's a very ambiguous way to. Second of all, the policy that Michael explained, there's nowhere that's in writing. That's changed at least 5 times in the last 20 years I've been here working on licensing in Miami Beach. They're not going to approve the license before, just because you file an application. Maybe they will right now, but.
That's the policy since I've ever seen it. We don't require somebody, if you have, let's say you have an entertainment establishment, a restaurant that is entertainment, we don't require you to shut down from the time you change ownership before you come to the planning board. That's why we have this process where, as long as you file an application to the planning board, pay the fees, we can approve the change of ownership administratively. It just forces the applicant to come before the board, it makes it a public hearing, the public can come out and speak on the application, the board can
Right.
ask questions.
That's not been my experience, and I've been doing licensing here for 20 years. On occasion it has, but it's changed back and forth, and I appreciate that, but, if you leave tomorrow, somebody else might say something different. Here's the real practical problem with that, though, and I'm in these meetings all the time. I'm on the phone at a conference with 10 lawyers from all over the country on one property. Let's just say it's a $300 million deal for the hotel. Nobody's going to spend $300 million on the chance that the public hearing is going to go the right way.
That's why I brought it up. I
That's the
agree
real,
with that.
and other than that, it's really not a problem, but that's the problem.
Well, that's why I'm
but
asking,
our-
that's
our-
why I said,
How do
what
you
are we?
tell,
Hold on.
how do you tell a seller, well, we'll wait 6 months before.
Well, that's
we
why I
close
asked
this
what
deal.
we're voting on. We
Like
can't
what?
be voting on whether to reject or approve the new buyer. I can't imagine that. I think what I'm
Transactionally, that's the
hearing
issue.
is that we're here to let them just kind of tell us about who they are, what their plans are, and that we kind of make them confirm they'll adhere to the, trust me, I believe that could be done in an affidavit, but
Which they
I
would do with the
understand
progress
wanting to
report.
hear from a new owner, but I don't think we can reject the owner.
You can't
Because I don't
reject
think
the
we have the power to jeopardize a $300
You
million
cannot reject the owner.
transaction.
Cannot reject
I
it.
can assure you.
That's why I asked you, when you said administratively you can approve it, then we're really not voting on the new owner. We're just kind of having them come here to tell us their plans, and we kind of say, okay, make sure you abide by the CUP. That's really what we're doing. We're not voting on approving the new
But
owner.
then there is no vote, so what would the vote be?
That's what I'm asking. That's why I asked them 3 times.
It's just making it more of a public process. So it's out in the open versus something so that the applicant or the neighbors are aware of the change of ownership as well. Otherwise, no one will ever know there's a change of ownership in this transaction.
Right, I just don't think the CUP should reflect that we are voting on to approve the new owner.
I also am concerned that I don't think that when we're issuing the affidavit, I don't think we're updating the CUP to reflect the new ownership. That I think is a flaw that somebody could use as an argument to, like the applicant did, to get out of a violation because the
I didn't
applicant
use
was
that
listed as
argument,
different.
but number two, you
One-
can
one-
update
one
the
second,
CUP.
one second.
It's a minor modification.
Elizabeth, hold on.
That was also my question I had written down just a little while ago. Is it possible there are other CUPs could be referenced by old code compliance
Oh, yes,
information
all
as
of
well
them.
as CUP numbers? I mean, I think that's should be a citywide, kind of update, seems like. Because if there's somebody that can slide in under that way, then there are going to be others.
So we disagree strongly with the special magistrate's orders in this case, because the specific code sections, the substantive requirements of those code sections are exactly the same. The only thing that changed is that they were renumbered. So it's very convenient for counsel, for the applicant, to tell you that there's no need to change the order when they just made that argument to the special magistrate, and the special magistrate dismissed the case on that basis. So
not correct.
I would recommend to you that you can, while we disagree with the special magistrate's ruling, I would recommend that you update this order to conform to the new code sections.
And are the new code sections what also require the new owners to come in? Or is that separate?
No.
Okay, so we're talking about two different
Two
issues.
separate things, right.
Okay. I'm just getting back to this, what we've been talking about, and I just think that it somehow should be reflected that we're not voting on whether to approve the new owner, since you will have already done that administratively. And that really what we're doing is just having them come in and introducing themselves and telling us, A, they'll comply, and B, if they have any plans of change of operation. So it's more informative than a vote. That's all I'm saying.
But that's the language that was in there, right? They shall be required to appear before the board, which is being struck. And the language that's being introduced is to file an application for a modification to the CUP. So if any subsequent owner would be filing an application for a modification to the CUP, technically we would be able to reject it.
And that's what I'm saying. I don't
Right,
think
so-
that's appropriate. I don't think we should be able to vote on whether a buyer of a $300 million hotel should be approved or not.
You're not, again, you're not
Okay, but
voting on a
that's
real
what it
estate
says.
transaction.
But that's what the
You're
language
merely
says.
voting on, when you do vote to approve a change of owner or operator, you're voting to conform an order. You're not approving a real estate transaction.
Okay.
So
all right.
I
It
wouldn't
just-
want to
the
misrepresent.
wording would suggest otherwise, but
There is no buyer or lender in the world that's going to spend $300 million on the chance that the hearing is not going to go the wrong way.
well, he
and it
just
won't
said
get
that we
approved.
wouldn't be approving or
that's not what
rejecting
Well,
the
but in
buyer.
practicality, that's what you do. I mean, I understand that's not what the board wants to do or what the staff wants to do.
We could
but
tweak the wording.
We have,
I mean, the
wording.
language
in
definitely
the real world,
supports-
that's what
Let's
happens.
change the wording.
The language definitely supports that
We would-
any
that we
subsequent
could reject
buyer
it,
would have to
right.
go in front of the planning board,
Right.
and then it could be
And we
rejected.
could
Can we amend
reject it.
Can we amend the
Because
language?
that came up with the W recently. That it really almost jeopardized a massive sale, and I know that as a fact. So I think the language needs to be
Yeah.
reworded.
I would suggest if the board wants to, don't amend that section right now, amend everything else.
Okay.
Continue the revocation modification hearing to next month. We can come up with some additional language or
Okay.
modification of the.
All right, last thing,
Finish
then
the
we're
answer
gonna
to
open
my
it to the
question.
public. Go ahead.
To the question that you asked too also. Look, when I say there's substantive changes to the order, it's not just changing the sections of the code. All right, there are factual statements in here, there are findings of fact, they're asking the board to make certain findings of fact that a modification is warranted based on the evidence and the record, which it's not. There's a lot of things in here that have legal significance. I don't want to bore you all with every detail, but bottom line is, aside from changing the code sections, there are a lot of changes to the order in this draft order that have legal significance, that are
Well,
quite
okay,
frankly
that's what
unfair
I
to the
asked
applicant. in
Michael.
this
Tell me
case.
what,
You bring
what,
up.
Yeah, I want to know
What
what they are. That
exactly-
is, I do want you to go into detail.
what exactly
because-
do you
Read from
object to? What exactly? I mean,
I-
are you
I'm
objecting to?
Well, the first objection is to modifying the CUP,
Okay, but
where there's no competent substantial evidence to justify that. Despite what the board attorney and the staff says, this is not a rehearing, this is not the appellate division of circuit court. Special magistrate ruled, the city presented its case in chief. The standard is competent substantial evidence, which is the same standard in this hearing, and the violations were dismissed. That's where that ends.
So you're objecting to updating the code information as well as the current CUP? I mean, what in the CUP, what are you objecting to?
I'm objecting to any
exactly?
modifications to the CUP.
Okay,
There's
what
no-
in the CUP are you objecting to? What modifications specifically?
Well, you're
If you don't
objecting to
mind.
all of it, but the reason
whatever
she's
you want.
asking you this is because we have the ability to agree to modify parts of it and not all of it. So
Correct. Okay.
we do need to know what.
Correct. Thank you.
Okay.
Did you change factual findings?
Everything underlined is changes, so, there's updates that are being made.
Where do you see underline? I don't see any underline here.
Based on the foregoing findings of fact, the evidence, information, testimony, and materials presented at the public revocation modification hearing, which are part of the record, and the staff report analysis was adopted, including staff
Sorry, can you guide us
recommendation.
which page you're reading, which number, what you're reading off?
I'm just reading it from the, page 2 of 8, that says it is therefore ordered, okay? And
These are standard terms, just for the record.
I understand their standard, but they have legal significance. You're saying something happened here that didn't happen. That's the problem. And I'm not trying to be difficult and nitpick
It did
this. I'm
happen.
just,
There was sworn witness testimony who came in to talk about the violations. We received the code violations. We saw photographs of a DJ on the premises without a special permit. We saw photographs of a percussion band, which was expressly prohibited in your, in the CUP. And in fact, the manager agreed when we asked the manager, I believe, they conceded that there were DJs and there were percussions on that night. They had explanations, but that's all in the record. So I don't know, when you're saying these things didn't happen, they did happen. I understand the special master found, for you on technicalities, but we're not the special master. There's, that is, if a special master were to find violations, that's helpful to us because it's additional evidence of violations, but we're not bound by what the special master found. That we heard sworn testimony in addition to all that. We're not trying to take away your CUP here. We're trying to just bring it up, bring it updated, make some tweaks to it to bring it to the new age. We don't want to be in a position where we're dealing with technicalities in the future, since that clearly can happen, since it did happen. And so
the word technicalities is being used wrong in this discussion. I just want you to know that. I know it's not intentional, but it's not, it's called the law. I mean, it's not technicalities.
Okay, so
And it was substantive, not
right,
just
so we want to
procedural.
make sure that our CUP is in compliance with the original intent of it and complies with the law. So I think that, obviously, we're going to get to public hearing, but, I just want to make it clear that these things did.
I don't think there's evidence to support modifying the CP. That's our position. With regard to changing the code sections, I don't think that affects it one way or another. No, we've never made that argument. I wouldn't make that argument. I think the CP has enough in it to support the fact of what the conditions are without changing the particular code sections. But there's a lot more than that in here.
Michael, is it your could it be a recommendation that the only modification we do today is to update the code and nothing else and wait till the substantive hearing
Sure, you could do
for
that.
everything else? Is that, okay.
And I just want to make one correction too, because it was indicated that there was no testimony previously regarding opposing the application. There was substantial testimony at prior hearings from the public, including playing of videos that was mentioned. And we have also email testimony that was not passed out, but it was part of the record previously.
We're going to stop right now and open
None
it
of
to the
that's
public.
competent substantial
Is
evidence.
there anybody in chambers to speak on this? No, okay. Anyone on Zoom?
We did have someone with their hand raised previously, but their hand is lowered now, so we have no, actually, yes, she's back. Sarah's iPhone 12.
And before Sarah, do any board members have any disclosures to make since the last time this was heard? No?
You have to disclose on a modification?
This is a quasi-judicial hearing.
Okay. Any disclosures? Talk to anybody? Anybody? Okay. I got a WhatsApp from Russell Galvin, but I didn't respond to it.
I didn't.
Okay. Go ahead, Sarah.
Sarah, do you swear that
Hi,
the
good m-
testimony you'll give in this proceeding is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You have 3 minutes.
I'm talking on behalf of almost all the associations that have hotels that are reside on residential area. This lawyer have said there is no infractions, there were no input from the public. I'm glad that you clarified that because there is a lot of problems with the Mondrian Hotel. They should not be
Sarah,
allowed
Sarah,
to do anything else.
Sarah, to be fair, just identify your address, please.
Oh, 1800 Sunset Harbor Drive,
Okay, thank you.
Miami Beach, Florida, 33139.
Thank you. Go ahead.
Anything else?
Nope.
So, because you know what? This hotel has had so many problems. We've been listening, all the neighborhood association, been listening to all the problems, seeing all the issues, all the code compliance stuff, even though he can say that there were none, or they went in front of the master, they were in front of the master, was dismissed, and it was not liked by planning. That should not be allowed. Definitely should not be allowed. I am surprised that Tim is not on today because, or either that or he's on vacation when they did this, because they do this most of the time in the summer when nobody's around. So I do want to make sure that I have a voice to them to help them out, because the Mondrian Hotel creates a lot of problems. They should abide by the rules. They live in a neighborhood that is a neighborhood, residential neighborhood, and they should abide by that. Thank you.
We have another public comment from
Lodge
Johan
a
Miller.
timely hearsay objection to that.
Johan, go ahead.
Johan, do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do. I was not intending to comment on this. It's not my neighborhood, but I'm going to back up Sarah and neighbors generally, and I'm going to make two blunt comments. There has been an incredible amount of arrogance from hotels claiming a right to inflict nuisance noise on neighbors in order to support their bottom line. And there is, if you will, a bit of a fiction involved in claiming that there are no violations because they were dismissed. It seems to be an argument in bad faith, and the public disapproves of it. Thank you very much.
Thank
Okay,
you. With
anybody
that,
else?
that includes our Zoom callers.
Let's close the public hearing. Questions, Scott? Go
Yeah,
ahead.
just jump, first, a couple questions for staff. When it comes to a modification, revocation hearing that we're in now, are there any guidelines that we need to follow to if we want to make any modifications?
I think the board can take all evidence that's been presented.
All evidence, but there's no black and white type.
It doesn't say you have to have a valid, or you have to have a valid noise complaint.
That's what I'm getting at. We couldn't, I mean, we could modify, even if there were no complaints, we could modify it, say maybe.
I don't think you would do that if there was no
No,
complaints.
but I
think
mean, that's obviously the main reason, but technically
You
we
can take the evidence, you know, you have, it's not, we're not talking about the volume of noise here. That could be like more subjective. You're talking about, is there evidence of a violation, and you have photographic evidence as part of the record.
Just to be clear, when you are reviewing a property in a modification or revocation hearing, you're bound by the code. You're bound by the conditional use procedure in the code, by the conditional use review criteria, and specifically when you're sitting in a modification or revocation hearing, you are looking at evidence of violations or noncompliance.
Okay. Another question. We talked about, as we do for what we're trying to get at is if there's a change of ownership, that most applicants can submit an affidavit. And I know for this one, you're recommending against that, just because of the history. If an affidavit is filed, does that automatically change the wording of the CUP to reflect the new owner, or do they have to come back to a public hearing and be heard by the board?
So, both have to be, excuse me, both have to be taken together. So if the staff or the city is not aware, or Code of Compliance is not aware that there's been a change of ownership with an affidavit, they could submit a violation on a property, and the applicant could appear and say, hey, this is issued to the wrong applicant. Because right now, I know that we are not modifying the change in the actual CUP. we're taking the evidence of the affidavit in combination with the CUP, but you have them both together. I don't think that's recorded in the public record, is it, the affidavit?
It is.
It is. It
It's
is.
a
affidavit is
covenant running with
recorded,
the
yeah.
land that gets recorded in the public
But
records.
we're not actually
So how
changing-
could you deny that it was changed?
But we're not
Okay.
actually changing the language of the CUP. The CUP is not being
It's
modified.
just the name.
But they're signing an affidavit and covenant
Right,
that
but we
gets
don't-
recorded
we're
in the
not actually
public records.
modifying- if
Who's
someone-
gonna walk in and say it's not my CUP?
But if you hand in the if you hand us just the CUP without the affidavit, no one's gonna know that that was modified with the affidavit. Because we're not actually modifying the actual CUP.
Correct. I guess that's my concern, because I was open to allowing the applicant to submit an affidavit, but I would keep I would make the other changes you're recommending and actually keep this hearing open till November. But then you mentioned that I heard someone say that if it's not in front of us, then technically, if there's a new owner and the first week he has the operation, there's a violation, that would be grounds to get the case thrown out at the special master, because it would be the old name. But if you tell me that the new name, once an affidavit is submitted, that new name is automatically attached to or is attached to the CUP, and that's the name on the would be on the violation, then I'd be okay with the affidavit for this application.
I think we found there's a loophole or deficiency in the affidavit where you could have a CUP being looked at that doesn't have the most up-to-date ownership information. That's something that we're gonna have to address internally.
Yeah.
And
Yeah,
probably
because
have
that's
to
a
physically
problem
update.
we may have on all the other ones that we're doing now.
That was what I was getting
Let
at.
me just add that no one can sign an affidavit that is also a covenant, gets recorded against the title of the property in the public records, and come into the city and say, that's not my CUP. It's a legal instrument recorded in the public records that confirms that, so.
But you got it dismissed. But you got the violations dismissed, saying.
First of all, that was not my only argument at the special magistrate. There's a mischaracterization in the staff report of those proceedings. It was not technicalities. That's an attempt to water down what was done by an independent judiciary who had sole jurisdiction over the violations. But further from that, there was no affidavit here. What happened was the code compliance had the wrong order. They based their violation on the wrong order. That was only one issue, okay? More importantly,
By the way,
affidavit will
can I
clear-
say something? No one bashing you for making the argument. Any lawyer would make that argument,
Right.
okay?
I had no choice.
No.
I mean, I don't-
Listen, you're doing your job, and that's what any lawyer would argue, is that they were all dismissed. So no one's, don't take this wrong. We're not bashing you about it.
I don't want there to
But
be like
as-
post-traumatic stress over that. The affidavit is very clear. City staff's done a great job on that. It's a covenant, it's an affidavit, it's an instrument recorded in the public records. There is no one that can have any legal basis to say, this is not my CUP after they sign that affidavit. They're 100%
No,
on the
I agree with
hook.
that. The only thing I would say is if the owners want to change operations or then I
Oh,
think-
they would have to come to the board to change it.
I'm receptive to that. I don't disagree with you.
100%. No one's going to forget about this property. It's going to be on the radar for a long time.
Right. All right, Scott, any other questions? Matthew?
I think we can't argue with the evidence that was previously presented, and I'm okay with the staff's recommendations to modify the CUP. I do have one question, though. Can you read the current language reflecting, in the order reflecting what would be done if a change in ownership were to take place today?
Sure. Just 1 second. So this is condition 2, and if you look on, it's included in the board packages of the original CUP, or the last CUP dated January 22nd, 2019, which says, subsequent owners or operators shall be required to appear before the board to affirm their understanding of the conditions listed herein. Any change of ownership interest in 1100 West Investments LLC exceeding 24% of the ownership interest in 1100 West Investments LLC shall be deemed to create a subsequent owner of the property, requiring said owner to appear before the board to affirm their understanding of the conditions listed herein.
So the order in which is currently in fact does require a appearance in front of this board if there is a change in ownership.
Correct.
So you're not changing that condition.
We're making it more formal, saying they have to file a formal application for that.
Okay, so I just want to be clear here. We're not imposing any, is that imposing a new?
Yes. I'm sorry to answer your question.
Go ahead,
before you
explain
ask
it, educate us.
Yeah.
Go ahead.
Yeah, so right now, what it says, the best way I could describe it is I'm a buyer of a real estate that has this hotel. Okay? The way the language reads now, you have your transaction, you close, you come in to affirm your understanding of the order to the board, and the CUP essentially stays the same. Okay? If there was an affidavit, you'd have the affidavit. Pretty similar processes.
But it doesn't give you the option of providing an affidavit. Right now, it says you have to
No.
appear.
What I'm saying is it's pretty similar to affidavit. But to answer your question, the change is, now it says, essentially, before you close your transaction, you have to file a public hearing application, wait the 3-4 months for that to get to hearing, get to a hearing, maybe wait until the appeal period passes, and then maybe you can close your transaction, which is, no transaction is ever going to survive a 4, 5, 6 month process like that. It creates. Yeah.
Michael, sorry, because I'm hung up on this language, and I'm sorry. But number 2 that he's talking about, you're striking out required to appear before the board, right? Which is what I always thought they should do, is come here just to affirm they'll comply with the CUP and tell us if there are any changes.
Right, so it just.
So you're striking that out to make them file an application to modify it to change the ownership.
And that's to require the public notice, because otherwise, if they're just under the
A
current
public
language.
notice that there's change of ownership?
Public notice that they're gonna that they're gonna be before the planning board.
Because remember, at the beginning of that paragraph, it says, this modified CUP is issued to 1100 West Investments LLC. So there has to be in orders that were drafted in this format, right? Because your newer orders, some of your newer orders use the affidavit process.
Right, but what does the public have to do with the change of ownership? I don't understand that.
It just requires notice to the public that there's gonna be that this item is gonna be on the planning board agenda, and anybody can make public comment on it.
And so how is it before this change? What happens?
No, this would have been just on the agenda. Let's say that somebody notifies us that they've made a change to the ownership. They would just let us know. We would put it on the agenda. We would only have it on the agenda online. It wouldn't be in the Herald notice. It wouldn't be in the mail notice. It would just be something on.
Right, and so since you didn't do that before, why do you think that needs to be done now? I still understand it.
To make the applicant and to make it a public process, just to make it stronger, that the neighbors are notified. They can speak on any violations or concerns.
Okay.
The
Also,
problem is that also requires a vote by the board to approve what is essentially permission to buy a property.
Well, that's why I think the language
That's
should be
not it.
modified.
It's not just notice.
Is there still a vote required today based on the current language when they appear, if they were to appear in front of this board?
Yes, because we're modifying the CUP
Okay.
to change the ownership.
No, I don't think that was the question. I
Well,
think the question was, under the current language,
Okay.
would that require the board to vote if there was a change of ownership? And the answer is no.
Well, I think you would want to vote to change the ownership.
We're talking about as it reads now.
Yes. We would, if you were to appear before the board, we would modify the CUP to change the ownership. We wouldn't leave it under the prior ownership.
So a vote would be required? Okay.
Yes.
So,
Then why would you have to add new language?
Well, under the current language, there's no filing fee, there's no time frame, so this would formalize that process.
all right, I just think it needs to be reworded so that it doesn't appear as though we are able to vote yes or no on a change of ownership.
So do you want to leave the condition as drafted, which says this modified CUP is issued to 1100 West Investments as owner of the property and its affiliates? Subsequent owners or operators shall be required to appear before the board. That's the existing language. You can leave it as is.
That's my preference, but
Okay.
obviously I'm one of 7.
Well, I don't have an issue with the current language either.
Right.
Okay.
Okay.
I agree.
All right. You won that one.
Well,
Yeah, I was just trying to give you the practical
I don't know if he
perspective.
won, it's still required
I think it's I know, but to make them file have another fee and file it when it's already, anyway. I don't want to, we got to move on.
I think
So
we definitely beat that one.
any other questions from Jonathan, Yashil?
I just want to, one other thing to point out. So in the code differences, am I correct that the old code that was cited here in that definition of entertainment did not include a DJ? And that the new definition of entertainment,
No, the
they
definitions,
did.
the definitions haven't changed.
Yeah, that's always been the case.
okay, is that, because I thought that that's what we had discussed at one of the last hearings, because didn't you have a position that a DJ wasn't specifically excluded under the CUP?
My suggestion would be we don't get into that issue, but in short, definition of entertainment doesn't mention the word DJ. I'll leave it at that. That issue is a little bit convoluted, has to do with interpretations of that definition over the years. It's on appeal before the Board of Adjustment on another property right now.
So
It-
given.
Same definition.
So given that, I think the clear intent was to, in the original CUP, was not to have DJs. And so I would want to clarify in the CUP, no DJs, given all the testimony that we heard. So that's, I agree to change all this language that we were discussing, not change the other language about the ownership, fine, but about the codes, I think we definitely need to update the numbering, but I would also add no DJs just to clarify that that was the original intent behind the CUP.
I would just ask if you have that intention, maybe you could consider that in the future. That makes this absolutely substantive changes. And also, as I mentioned, that issue is before the Board of Adjustment in October. So maybe it might be a good time to table that item.
I would
Just a
suggest we don't modify that today.
I agree. Okay.
Can we just continue this? I think it should be continued.
I think we
It is
we
being
need,
continued,
Okay, I just wanna-
but we're,
we need to at least change the code sections.
The code
Yeah, let's
section.
tweak the code sessions.
Right.
And we leave it open, right? And we'll come back at another date to address that.
May I suggest that we continue it all the way to November instead of October, just on the basis of, I find it very hard to evaluate some of these businesses that are during their operation during the summer when it's the quiet season.
I
We have a
agree.
much more reflective picture of the business once the high season begins. So I think if we push it to November, it gives us more time to see
Agreed.
what the.
I agree with you.
Considering though that, again, there was no one from the public here speaking out, I mean, previously we saw 5 people here, whatever it might be, 6 people speaking out, against the applicant. They're not here now. I mean, is there?
and
any-
5 people supported it in affidavits.
Well, no, I mean,
Emails.
I'm just saying, to at least, I don't agree with the language. I'd make a motion to
Well, yeah, we're not going to,
essentially to dismiss this, I mean, to bring it back again to hear it. If there's another violation that's held up, then we obviously.
you're
it would
saying
go
make
back.
no changes today?
I'm saying make no changes.
So
I mean,
I'm going to
based
make a
on-
motion, we'll see if it passes,
I'd make a motion to dismiss the progress report with no changes.
and
made
bring
to
them
the
back in
CUP.
November.
Oh, and not bring them back.
Oh.
I mean, just, again, there's no outstanding violation.
Yeah, again, I just think
There's
it's
no
not.
one here from the public that's come out here saying.
Correct, but we're September and
there's
it's not
more of an
very
issue.
reflective. I
We've
think.
got letters of support that's come in.
So you
Yeah,
don't
well,
want
there's
to,
5 letters too that come from the same
Hold
company.
on, everyone, one at a time. Shield's making a motion that we dismiss
Oh, okay.
the status report. That's your motion, right?
That's my motion.
Okay, is there a second? No second. Okay.
Are there any
I'll
amendments to it?
I'll make a motion to modify the CUP to reflect the new code numbering as recommended by staff, to omit the recommendation, leave it out about the change in ownership, and then to continue.
Well, actually,
I have
it'd be
to do
clear
it,
if you
yes.
just say to adopt the new code and that's it,
Yeah, but you know where I'm going.
and defer the rest.
Well, I'm saying, and then later I can make a second motion to continue the progress report or CUP modification hearing until November.
Okay?
So the only thing that would be modified right now is just code, nothing in section 2, correct?
Correct.
Correct.
I'd second that.
Okay. We have a second. Do a roll call, please.
Mr. Frieden?
First?
Yes.
Aye, yes.
Ms. Beatty?
Are you sure?
Ms. Beatty?
Yes, please.
Mr. Cement?
Yes.
Mr. Koltenoff?
Yes.
Ms. Latone? Mr. Needleman?
Yes. Are we going to take another vote on
Yes.
the?
You can call me, by the way.
Oh, sorry. Mr. Elias.
Right, yes.
So that motion passes 7-0. We're going to modify the CUP just to reference the changes to code sections.
Correct.
And we continue this into November.
And a motion to continue this to the November 26th meeting?
Is that a
Right,
separate-
and I want to make sure, Jonathan, the reason for that is,
Well, the reason for that is, I think that we should be talking about, like, there's clearly, they're making an argument that there's no DJs, or that they're allowed to have DJs. And I don't think that that is the intent. I don't think that's what the neighbors signed up for. I think that there was a change in the code that had a different interpretation. They're arguing this, and I just think that that's something that was the whole time.
All right.
They got a violation for it. It wasn't upheld by the
Right,
magistrate
right.
because there's argument. So not only that, but I think that we should, regardless, give it more time to understand, you know, there
see if
were.
there's any more complaints.
Exactly,
Okay.
and we don't have
All
anybody
right,
here.
that's
to-
fair. All right. Well, so the motion is to bring them back in November for a status report?
Second
Or wait,
that
would it
also.
be a or would it be a
No,
modification?
Modification.
All right. Till
Second that
November.
also.
Okay, do I have a second?
Aye.
Elizabeth seconded it? Okay. Roll call?
All in favor?
Yes.
Yes.
Opposed? Okay. All right, so behave until November, please. It was longer than I thought, but important. Okay, next file is another revocation modification hearing, Planning Board File 210442, 743 Washington Avenue, Vendome.
Just a second. So this application, the history for the current application for the board. On May 29th of this year, a cure letter was sent to the applicant for the CUP that was last modified by the board on July 27th of 2021. The cure letter requested the applicant appear before the board for a progress report on June 25th. On June 25th of this year, the board discussed the progress report and continued the report to the July 30th meeting. On July 30th, the board discussed the report, the progress report, and actually set the revocation modification for a date certain of today. As noted in our staff report, the property had received several violations, including for the installation of a sculpture on the property without obtaining a certificate of appropriateness, as well as violations related to the CUP for the application of window tinting and for the obstruction of the public sidewalk due to patrons queuing in front of the establishment. We also noted that a violation was issued on June 5th of this year for failing to provide written notice to the Miami Beach Police Department for a performance that occurred on June 7th. This violation was appealed to the special magistrate, and on July 15th, the special magistrate denied the appeal with an adjudication of guilty. Now, at the June 25th meeting, the board did request that the applicant present operational plans to ensure that no queuing would take place in the public sidewalk. And the board also asked for the number of promoted monthly events. This information was not provided to the board at the last hearing on July 30th. Since that time, the applicant has submitted a queuing plan. We have included it to the, as an attachment to the staff report. And this is an attempt to ensure compliance with the condition prohibiting queuing on the public sidewalk. This queuing narrative, which the applicant will explain further, includes a two-phase approach, which the applicant has stated has allowed the queuing to be contained completely within the private property. Now, the applicant has not yet provided us information regarding the number of monthly promoted events. And additionally, staff is recommending that the applicant update the queuing narrative to include an affirmative statement that no queuing will take place on the public sidewalk at any time, as well as a plan, a site plan that illustrates the various checkpoints. We are recommending the board modify the CUP at this time to update the reference code sections, as we mentioned, for the prior revocation modification hearing. We're also recommending that the CUP be modified to reflect the latest queuing plan provided by the applicant. And these modifications are included in our attached draft order. We're also recommending that the board discuss the substance of the prior violations and consider whether additional modifications may be warranted. In addition to providing the updated queuing plan and promoted events information, the board may want to consider limitations on the number of promoted events, or requiring, for example, like with the Mondrian, where those promoted events can only happen as part of a special event issued by the city. So for that, we are recommending that the CUP be modified as indicated in our draft CUP, and that the revocation modification hearing be continued to the October 29th meeting. With that, I'll turn it over to Mr. Romero on behalf of the applicant.
Before, so you said they did not provide information on promoted events?
Correct. I
And that
believe
was
Mickey's
my
gonna
big
discuss that.
concern, so I'm sorry to hear that.
No, but I can explain that.
All right.
So, good morning, Mr. Chair, members of the board. Mickey Marrero here on behalf of Vendome nightclub at 743 Washington Avenue. As noted by Michael, we're here on a revocation modification hearing. I did submit a presentation. If that could be shared, please. Thank you. With me today, my partner, Michael Larkin. So I'm just going to go through a little bit of the history, because is there any way we could get the, I guess not, but anyway. I'm going to go through the history of this business so you guys understand, because a lot of
By the
you.
way, we don't see that, so it's okay.
Okay, I know what's there, so. I'm okay.
Yeah.
This was previously, and if you can go to the next slide. Or do I do this here? Okay, so just, this is a view of the venue. It's a relatively small nightclub on Washington Avenue. Previously was a venue called Rockwell, and I think there's been some confusion as to when there was a change. Michael mentioned that there's just an aerial. In 2021 was the last time prior to this series of events that the application was here. We were here on that. Our clients purchased this property, purchased the entire business from the Rockwell operator. It's been 2021. Rockwell essentially suffered, they were a victim of COVID. They were not able to survive, and these gentlemen bought essentially the business, rebranded it, but it had been in existence for many years prior. And here you see, when it closed during the pandemic, but now Vendome purchases it, and it becomes a new venue. 2021, the board approved it. We also had to go to the Board of Adjustment to modify that order, and from then on forward, it was operating, we believe, in a good manner. One of the things that was requested was a queuing plan. I'll get to that in a second, but before that, I just want to go through the history of the violations. I got into a little bit in the July meeting, but I think it's worth mentioning again because I think it's really important. So the cure letter was sent May 29th. What triggered that cure letter was, at that time, 3 violations. One of them was for a sculpture that was installed without a permit. I want to reiterate, that sculpture was there when Rockwell was there. We inherited the business, we inherited the space, and multiple departments, planning, code, multiple departments, I was there, did inspections of that property. This sculpture issue was not raised. My clients liked it, they kept it there, but they didn't put it there. The minute the violation was issued, sculpture was gone, it's not there. Another violation was for tinting. Again, same fact pattern. The tinting was there from the prior operator. They didn't change it. They left it the way it was. Inspections were done by the city. It wasn't raised. They operated for 3 years. It's been fixed. It's been removed, but they didn't know it was an issue. On the queuing, there was an absolute instance of a queuing problem. It wasn't just that day. There was one violation. I know Mr. Frieden and I, we spoke about it in detail. They recognized that queuing could be an issue. So they actually proactively addressed it. If that's hard to read there, it just kind of shows you that we submitted. If you can go to the next slide, it kind of shows the drawing of the queuing.
When did you submit this, if you don't mind? When did you submit the queuing plan?
The actual queuing plan was submitted a couple weeks ago.
Couple weeks ago,
It was
okay.
implemented, that's getting someone to draw it up, but it was
Okay.
implemented since June.
That's what I want to check.
And what they've done essentially, they used to have one spot where the staff, and again, if we could, I'm the one doing this, I'm sorry. Different venues, you have different tech. So what they used to do is the same person that would check you for your IDs would pat you down, and it was basically, when there was a little bit more people in the line, would create a jam. It was never a huge jam, but what they've done is they've now made it a 2-step process. So they bring the people within the property limits, not on the sidewalk. One person's checking for your ID, checking for, for credentials. Another person would then pat you down, check for any illegal weapons or anything you're going to have on you, and then you can pay and go forward. Since they've been implementing that process, and I think this is really important, there have been 68 proactive investigations by code. What that means is, without a complaint filed by a neighbor, without anybody calling in, code, and I guess there's been this spotlight on nightlife. Maybe it's a competitor create. I don't know what it is, but I've never, in 20 years of my doing this, seen one establishment have that many proactive investigations. Maybe it happens, but I'm not aware. But again, and I counted these yesterday. I have all the dates here, and 68 times code was there to see if there was a queuing problem and other issues.
Mickey,
And-
may I ask a question
Yes.
real quick while we're on this topic? So this plan was submitted 2 weeks ago?
Yes.
Was this implemented 2 weeks ago?
No, it's been implemented. They've been operating like this since June.
Since June?
Yeah, but I had them, and when we discussed it at the last meeting, but I had them draw it because it was a request to submit prior to this hearing.
But you didn't have a queuing plan at the last meeting?
Well, they were still operating in this fashion. They just drew
Okay.
it. But this is how it's
has
being
been
done.
this has been in compliant, I mean, you've been operating under this
And
ID
we're-
check and all that? Okay.
Yes, it's
Okay.
been operating this way, and the reason it's important, since that May 29th violation, going back 4 months, 68 times they've gone out, sometimes 3 times a night. They're only open 3 or 4 days a week. So they've gone, and I work great with code. I think they do a great job, but clearly there's been an effort by the city to make sure nightclubs are operating responsibly. And I think the fact that, look, if you're the best driver in the world, but a police officer's following you around 24/7, you might eventually get a ticket, right? And I think that's what's happened here. So since May 29th, 68 times they've been there, and in all of them, there have been exactly 0 violations for queuing. So to me, that is evidence that they got that. It was a minor problem, created some issues. They found a solution, and it worked. It's just 68 times where they're 0 for 68 on violations for queuing. I think that's pretty strong evidence that the plan is working. Since then, there have been 2 additional courtesy notices issued. One was for, again, the whole perfect driver with a police officer behind him thing. There was an issue with the door, was a little bit, in disrepair. They fixed it. I think there was just a courtesy notice, and there was another violation issued for graffiti on the property. And the violation itself says, unfortunately, a vandal has defaced your property. They don't actually control the area of the graffiti, but I contacted them. They spoke to their landlord. They're dealing with it. It turns out, and I don't even know the science of all this, but the graffiti, the vandal that put the graffiti on that building, which is controlled by the landlord, did it with some sort of acidic product that's very hard to remove. So they have to hire a specific consultant or service provider to remove it. It's being done, but it wasn't them, and it wasn't even on property they control, but they're dealing with it. Another thing I want to, Mr. Elias, for your specific comment on the promoting event, and I did mention this to Michael, depending on what we characterize it as, every single day they're open could be a promoted event, or maybe 0. But let me tell you why. The way that this business operates, they generally, let's say an artist, it could be a local artist, it could be a celebrity, it could be a performer is in town. They pay a fee, and that person comes to the club. What that does is, if it's a big celebrity, someone that people know, it may make the tables a little more expensive for that day, but they have some DJ or someone almost every time. It doesn't increase the capacity of the place, and most of their clientele reserve tables in advance. So there was a little bit of a hiccup.
Wait, are you saying promoted events don't increase your not the capacity, but the attendance?
Yeah, but they limit it by the number of tables that are sold, and they don't
Right,
oversell.
which is what causes the queuing, because you promote it, thousands of people come.
But there's never thousands of people because, and again,
I've seen videos
Well,
that say otherwise.
so that brings me to this. Just last week, do you know who the cryptocurrency guy is? The Malone Lamb, I think his name is, he was indicted for $240 million of theft of cryptocurrency. He's 20. He got into the club somehow, and if this was implemented and being practiced for the past, since June, I don't understand how this guy was in. He's throwing $2 million around the club and saying, this is what happens when you get indicted, and that's underage drinking. So I'm trying to understand, if this has been in practice, how are underage people who have been indicted for fraud, theft, all that, getting in the club? I'm just curious.
I don't know anything about that individual, who he is, or any of the background.
It's on Vendome's Instagram page.
Okay, yeah, I just, again, I don't know.
But it is like, that's underage drinking.
Yeah, and then, again, I don't know who that person is, I don't know his age, I don't know about the
Well,
indictment, so I
but I'm
can't speak to
telling
that,
you.
but I'll look into it. Again, so I'm looking at the history of violations, I'm looking at all these problems that have caused it. As far as the one violation that related to notice, what they do, and I'm copied on all these emails, they notify the police department every time. If the person is a big person, if it's a small, name I don't recognize, they still notify in an abundance of caution. There was that one violation where they notice went out, the timing was a little off, so we did appeal it because they do this hundreds of times and it's never been an issue. This particular time there was a discrepancy between the marketing folks posted something on Instagram and the actual contract was filed. We showed all the dates, we showed the contract. Special magistrate said, look, it occurred, but it's obviously a clerical mistake, so she removed the fine. And just to show that it was clear that it wasn't intentional and that they otherwise have an incredible history of following that regulation. And that's essentially, but if we say that every time they have to notify the police that a person is there as a promoted event, then every night they're open is a promoted event. And that's just their business model. And again, it's a business model that doesn't create noise issues, that while there was a queuing issue, it has been resolved. At least the evidence shows that someone's checking on this almost every day that they're open, if not multiple times a day they're open, and there's been no violations. So there's a two-check process. They're open generally Thursdays, Fridays, Saturdays, and Mondays every week. And most of those times, they do have someone that they notify police, hey, this person's here, just in an abundance of caution. That sometimes it's...
Most of the time, but not all of the time.
They notify?
Mhm.
Yeah, every time.
I thought you just said most of the time. No?
No, all the time.
Okay.
Yeah, they notify every time.
So, again, I want to come back to this underage thing. If you've got somebody there that's IDing at the checkpoints, and you've got somebody that's obviously throwing $2 million around, how is it that people don't go, hey,
Because he's throwing $2 million around.
Yeah,
I mean, right?
That's why.
Look, he probably has a really good fake ID maker. I don't know who that person is, so I can't really speak to it. But if somebody was a few months before 21 and got in, I don't know.
I think what she's getting at is that, you're talking about the queuing plan and how you're gonna have people checking IDs here and that. And if someone that's underage can get in and get right past that, I think she's questioning the queuing plan, the whole plan.
exactly.
Again, the queuing plan is really to make sure that there's not queuing on the sidewalk.
But it's also
But-
an ID checkpoint is what you've written down, and you said that it's been an
Well,
implementation.
My clients are available by Zoom to address this, but I will tell you, I'm sure they checked that person's ID. And maybe that person had,
Okay, so who?
How about the back door? I hear a lot of people coming through the back alleyway door.
Right.
You know anything about that?
Me personally, I do not know.
Let's get your owners on. Yeah, let's if they're on, let's get them.
And then, so they're
Wait,
available
all
by.
right, well, hold on. Is there anyone on Zoom?
And before we go to Zoom, do any board members have any ex parte communications to disclose? No? Okay.
It's since the last one, right?
Yeah.
Since the last
Since
hearing.
your last
yeah.
disclosure.
And Mickey, are you putting on the owner during your case in chief, or is this?
They're available to answer questions, so.
Okay.
Yeah, but I'd rather
they
hear
signed
from
in.
the public before and then.
What is
let them-
their Zoom name?
One guy's named Adele, the other guy's named,
We have somebody with their hand raised. Gil?
yeah.
No, but is he the only one on Zoom?
Yes.
All right, is there anybody in chambers to speak on this?
Hello. Hi, Troy Wright, Executive Director, Washington Avenue Business Improvement District. Happy to see everyone here. To me, Vendome, they're great operators. They do a great job. And without mentioning any names, this weekend, and I can't tell you who specifically unless I had to, one of the top mayors in America was my guest here on Miami Beach. His team said, hey, we want to go to a club or a venue of entertainment on Miami Beach. Where do you suggest? I took them to Vendome. Their response was, this is one of the most diverse, safest clubs that we have been in. We would love for a club like this or venue like this to be in our city.
Where was that?
Hold on, this was this weekend, and I took them to Vendome. It was I can't tell you. And if I need to later, I may be, but I won't. But I'm under oath, so this is what it is, right?
But that's who we're working with. People see Miami and the venues that are that operate here as great establishments. Yes, there are problems here and there, but for Vendome, they have been a great operator. They do not allow a lot of issues. It's safe. It has diversity. It gives everything that people want in entertainment here on Miami Beach. So I'm not sure where the disconnect is completely, considering there are bad operators other places. But for Washington Avenue and for Vendome, I believe that they do an amazing job.
Thank you. Anyone else in chambers? Okay, the only one on Zoom is the owner.
Hi, Gil. Do you swear or
Yes.
affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
First of all, I'm one of the partners of Vendome. My name is Gildas Melot, from 743 Washington Avenue. Everyone can hear me very well?
Yes.
Okay, I'm sorry. So first of all, I want you guys to understand that our main priority is the safety of the venue and to make sure we have a good impact on the city. So this is very important for us. So we have 0 incident in all of those years inside the venue. We don't have fight. We make sure to have extra security so everyone can feel very safe, just like Mr. Troy just mentioned. I want to touch the 2 topics that I see that are very sensitive beside the queuing at the door. I heard you were asking if there's a lot of people that go through the back. The back entrance are only used for the owners and the staff. Once in a while, when there's too many people, the owners go directly to the back. So this is something that, yes, I can walk me and my wife and a few guests through the back. Regarding Malone, the case of the crypto scammer, first of all, we had no idea he was a scammer of this size. You must understand, a kid like this came with a lot of money in town, and obviously,
Do you check for his ID?
yeah, yes, I was about to touch this point.
Okay.
He never spent $2 million in maybe he spent $2 million over the week in Miami, but not in Vendome. In Vendome, I think he spent like around $150,000 or $200,000. This is what I've been hearing from the partners, but very far from $2 million. A guy like this came with 5 bodyguards, to give you an idea. He's extremely wealthy. So we saw him as a client, and he has a real ID on him. So as much as we can check, you must understand that we stop like 50 to 40 underage left and right, or people trying to come with wrong ideas. But a guy like this that is extremely wealthy have the way to find real ID. So I don't know how he did it, but he must have purchased a real ID, and that's how he got inside the venue. So we stop all of them, we pat them down from the security, so to make sure we're 100% safe. But we also check IDs, and that's how he went through. He passed through the code,
Do you bring people in the back with you?
Yeah,
Other than family, and what
He can
kind
be
of?
a guest.
Like the chair has said. Also, I've heard that the back is also a kind of a hot spot for bringing people in without having to stand in queue.
No. The only entrance is in the front. What we can bring to the back are like a big VIP or a celebrity that don't want to be seen. So we do a full checkup even through the back. Let's just say I have a very big celebrity or have like someone that want to be discreet. We just walk into the back and we do the same process, ID and checkup. But it's extremely rare, to be honest.
So, $200,000 is 200. What was it? 250. I feel like there's just something that's missing here, and I'm trying to put my finger on it. Maybe you can help me.
I don't have the exact numbers with all the respect, but I do know because I heard you mentioning that he spent $2 million. He didn't spend $2 million. This is 100% sure,
Just ask the applicant. The club, restaurant, whatever it was, has been there since 2008. You guys took it over in 2001, about 3 years ago.
21.
I'm sorry.
2021.
2021. And apparently there were no violations for about 3 years. What's changed? I mean, what are you doing differently now? Because maybe we can address that.
Yeah,
in a
I know
modified
exactly
CUP.
what happened. So what we were told, there was a shooting at another club called Exchange around the spring of this year. Terrible tragedy. There was a fight between, I guess, that bouncer and some disgruntled, inebriated client came back. Nothing to do with Vendome, but code was directed, my understanding, to put a tighter look on all the nightclub establishments throughout the city. And I think that's why you've seen all these proactive investigations. Probably not just this venue, it's probably the other nightclubs. And again, so that's really what's changed. And because of that, little things like, was that sculpture permitted? Again, the city had been there. They'd looked at the sculpture. No one raised the issue. We had no reason to know it was not permitted. We removed it immediately. But little things like that were never brought to anyone's attention. Those have all been resolved. The queuing issue was one violation. And since then, they've implemented a plan. We've submitted it. We're happy to agree to a condition on that plan. And it has resulted in, since that day, 0 violations despite 68 visits regarding the queuing issue. So I don't think anything has changed in the way they operate. It's only improved. But it's definitely a lot more eyes on this and other venues as a result of an incident at a completely unrelated venue.
Well, it's just something, I guess that's what the kind of the direction the city's going in. It's I guess a lot of the clubs are and some are managed and run better than others. But, in general, the city's having some issues with clubs, shootings, whatnot, obviously.
Especially in that area.
There's obviously, I'm not going to, again, point the fingers at you. I'm sure there's a lot of underage drinking going on in clubs and things like that. So, I think the direction the city needs to go in is to maybe crack down a little bit and do things to try to mitigate some of the issues. And I think that's what we're here for now. I mean, queuing is one. I mean, I know we can look at other things like, how many events they can hold, special events they can hold. I mean, I'm open.
Well, that's my
to
concern. When
other
you say
things.
every day is a special event, I find that, listen, you're a great lawyer and I know you have integrity, but I find it a little disingenuous.
Because let me explain why, though.
Yeah.
A special event, what that means is you're exceeding what you're allowed to do. You want more people. You need a bigger occupancy. You have to have special valet that day. None of these things trigger any of the criteria for special events.
How many
It's
people
just
are allowed in the club?
he can
Well, I
answer
don't know
that.
if special events is the right word. Promoted events.
Right,
Like when you get on
promotions.
Instagram and you put, oh, we have so-and-so here and we have so, I mean, you're just asking for problems. If you ask me, if you do them every day, especially.
It's every, they're not open every day, but when they're open, and it happens, it generally happens, and I see it because I get the emails to the police that are sent, like weekly, and maybe it's not, let's say they're open twice in 1 week, and it might be twice. I don't know the names of all these artists. I recognize the name of some of them,
Right.
but they notify the police in an abundance of caution just to say, hey, this is who's going to be here. If the police choose to make, there's any reason to be concerned about that person. There generally isn't. Generally, things don't change on the enforcement side. But there's a code section that says you have to notify when there's, because most places, that's what they have. They have some talent, some degree of talent there when they're open. There's less overall clubs than there used to be. And I can tell you, many, many lifetimes ago, I used to promote at clubs in Miami Beach. And it was just, you just kind of went. Now, the business, there's less of them, but there's more, there's more of a draw to a specific talent that's there, be it a DJ, be it a celebrity that's there to say hello, or someone that performs 1 or 2 songs. They're not really concerts. It's just an appearance. But that's a big part of their business model. And again, it doesn't, other than the one violation that they got, it really doesn't seem to have created, especially now that it's been addressed by this plan, any ongoing queuing issues.
I feel like I'm going to just keep coming back to the underage drinking. If it's on Instagram, if it's on the public domain, that somebody in the club wouldn't have seen, oh my God, and it says specifically when you've been indicted for $240 million, and that's been out there for over a week, and nobody from the club has addressed that at all. And I don't know, I feel like the club would have said, oh my God,
And
we
just
better
to her
take that
point,
down or
the
something.
kid that was 20 posted on his own social media that he was at Vendome and spent like an ungodly amount of money.
And he actually said
and he's
2 million,
But I guess, I mean, the owner made the point, like, he had an ID, a real ID, you can't, I mean, what are they supposed to do? I mean, do a full background check? You know,
I
if they have
guess
a real ID,
when it's
that's
on
that's
social
a
media and
felony
it says
that-
you've been indicted for a crime, then
I
you
think that
might
was
want to go
after.
back and visit that.
That was afterward, though.
Yeah, I don't think this is the issue at hand here, a alleged criminal,
But it kinda is.
going to a club here. You know, we talked about the queuing, and we talked about the number of promoted events. We're not the police, and our job is not to enforce the age restrictions, I don't believe.
Well, it kind of is part of their CUP and
If I may talk.
operating legally. But I will also say, I don't think that operating between, just having queuing specifically between 12 a.m. and 1 a.m. is sufficient. I mean, what time do you open?
They're usually around 12.
At 12?
Yeah.
And you close at?
They depends on the evening, but generally they're open till up to 5. It could be as late as
So-
5.
I think that it needs to be extended to that. I think we need to look at promoted events. I think there needs to be some things that are addressed there. And I don't know, Michael, what are your comments?
Well, first, let me just comment on, just so everybody knows, what is defined as a promoted event. So it's actually defined in the code under Chapter 6, which is alcoholic beverages. And a promoted event or concert shall mean any live musical performance or live entertainment in which an entertainer is advertised or marketed to perform at an alcoholic beverage establishment. So when you have a business serving alcohol with entertainment and occupancy over 350, that triggers a whole set of requirements, including notification of the police department. That includes the data performance, the performer, contact information regarding the performer, the number of tickets sold for the event, as well as a security plan for that event. So there's a whole range of requirements for that. So we're
And
suggesting,
is there any limit to how many of those you can have?
not in the code,
Okay.
But
So it'd
that's
have to be in a
something
CUP.
right?
And you're saying this is every day you're open?
A majority of them, yeah. And again, it could be a DJ. It's a very
It's
broad
any live
definition.
performer and you're promoting, right?
Yeah.
So
They
it's
have them
literally
there.
every day you're open.
Maybe we should limit the live entertainment or the promoted events in
But-
some form.
Can I ask, I mean, I may be missing something, so, but it seems to me they had a queuing issue. And it's clear that their business model either started as or became, having performance artists or DJs or it became that. It's clearly very profitable for them. They have fixed or cured the violations that they got. Some of them, are, not as important as the others. But they fixed them all. We asked them to come back with a queuing plan. They did. There doesn't seem, we heard the police data from the last time we were here. There did not appear to be any issue at the actual nightclub. It was, maybe there's some things that once people leave the nightclubs that they have no control over. There's, I don't understand we basically would be forcing them to either change their business model or close because of this queuing issue that occurred. I'm accepting the representation that 60-something times code has gone out and there's been no violations found. So it seems like they've cured the issue, and I just don't see what we're chasing after in terms of the special events. I mean, frankly, if they don't have the quote-unquote special events, then they're
Promoted events.
promoted events, sorry. Then they're doing having less interaction with police in the city, and I would like for them to be having the more of the interaction. It sounds like they're meeting the requirements, except for one or two situations, which have been addressed according to the council. So I just I don't know what limiting the promoted events would do, other than force them to either change their business model or close. But, when you have, a performer come in and grab the microphone and be in the nightclub at their table the rest of the night, that's seems to me that's a pretty standard South Beach sort of thing. And there doesn't seem to be crime at this venue. They've fixed the issue of the queuing, and so my position would be, if you want to leave it open for another couple of months.
Yeah, Jonathan, I was going to suggest that. Why don't we continue it and let the crowds come back and see how that works with the queuing plan and,
Sure.
see how that works and see if, check IDs and see what's happening. What do y'all think?
So we'll make a motion to continue it to,
But hold on, do you want, we're going to modify it to include the updated code, correct? Like the last one?
yeah.
So, yeah, we're recommending that the board at least modify it to include the updated code sections. Similar to the last application, we did
Sorry,
change.
Just to clarify and understand, so if we're making this motion, I guess, to continue it, what are we looking for to happen between now and then?
See how they behave.
So just to continue to see how,
Making sure that it's compliance.
It's kind of like, when you're monitoring a nightclub or a hotel, in August and September, sort of fruitless.
Correct.
So.
You're in Maine.
so
All right,
this
so,
would be
all right,
continued to
we
when?
got to move on. First, well, hold on. First, do a motion, Jonathan, if you don't mind, to adopt the updated code as part of the CUP.
And just one clarification on that, we had also recommended modifying the affidavit requirement. This CUP was actually modified a couple of years ago to allow the affidavit. So we had recommended going back to the requirement that they file an application for modification. So if you want to exclude that, we can, or if you want to include that.
Can it
it's
be the
drafted.
same as last time? They have to come before the board? The
Well, right now,
language?
so what's different here compared to the Mondrian is that the CUP was modified in 2021 to allow them to submit an affidavit.
Right.
So we had suggested going back to the old requirement of filing an application for modification. If you want to keep the affidavit, then we won't
Isn't that what
modify
we
condition
just, though, in the last one decided not to do?
It's
a
a
little bit
different, the
It's
order
a
was
different-
drafted,
it's different.
it's a different order.
It's a different
So-
order.
All right,
The previous one just had them appearing before the board, this one has them filing an affidavit.
Correct.
right. So,
So, I would move to accept staff's recommendations, which are to make that modification. In addition, I think there was one where they were gonna comply with the, queuing plan that they've submitted.
Right.
And then also the code, numbering changes as well.
okay.
And
Do we
we're
have a
okay with all
second?
those changes.
So we are, so just to be clear,
So,
are we modifying the condition
yes.
outlined in the affidavit?
His motion is to modify it as you've requested.
Okay.
To accept staff's recommendations and modify it as proposed. And
We
you
will
don't have
update
any
the
issues
queuing
with that.
plan.
No objection with that.
This will include an updated queuing plan with a site plan, as well as a statement that there be no queuing on the public right of way.
Right, and what we've submitted satisfies that requirement, correct?
Are y'all okay with the hours from 12 to 1? Do you want it to continue to 2 o'clock? What are your thoughts
As far
there?
as what?
The
For
queuing.
the queuing, I mean, I think
Because
the
if they're
queuing
open
should be
until
up.
5
the
a.m.
queuing plan should be for all
Yeah.
The
hours.
whole time,
Queuing
no, that's
should
fine.
be-
That's
yeah.
when the general people come.
should
But yeah, we can,
I mean, are you?
That should
All
be
operational
modified.
hours.
So the
Operational
motion
hours,
will
fine.
include that
Okay.
the queuing isn't limited by 12 to 1. It's
Correct.
Closure.
5.
no objection
Thank
to
you.
that change.
All right, do I have a second?
I'll second it.
Okay.
Wait, who made the motion on that again, Mr. Feeden?
Yeah.
Jonathan made the,
And we're continuing still November, right? Is what we
Right.
agreed on? Right.
Separately, or?
is November just ridiculously busy? The
Yes, and it's the
agenda?
day before Thanksgiving.
No,
just
the
so you know.
agenda.
Yes.
It is pretty busy for October, yes.
Why don't we do December?
Yeah, let's do
Yeah, let's do
December.
December.
So let's do the first
Now
motion
we will
first.
really have a gauge of what's
So we
going on.
have a motion and a second to modify the CUP as referenced. All in favor of that motion?
And with the modification that
And the hours.
That the
Right.
hours are
Right.
until close.
Correct.
Okay,
and-
all in favor?
Aye.
Anyone opposed to that? Okay. The second one
And
is
a
to
motion
bring
to
them
continue the revocation modification
to
hearing.
December.
to
I'll
Dec-
second
Actually,
that.
we canceled the December meeting.
Oh, we
So,
did?
Yes.
We canceled what?
Well, thanks for
December.
letting me know.
December's
Because- right,
canceled?
Because we, remember, starting next year, we're moving planning board to the first Tuesday of the month versus the fourth Tuesday,
And earlier, right?
9 o'clock.
Yeah.
We're also starting next month at 9 o'clock.
All right, so we'll move it to January.
Or you can, I would suggest November at this point, just to,
Okay.
Oh, but, sorry, can we move it to January so we actually get the winter months in there? So if there is gonna be an issue.
up to the board, I mean, what do
Yeah,
you
let's do
prefer?
January, and if there's
January.
complaints in the interim, then, you'll
Well,
let us know.
that's more time.
I mean, that's high time, so.
All right, so Jonathan, your motion is
But I would
to,
suggest, if we do it in November, then the board could take action if there are any additional violations or,
right, but our point is that they're more likely to get a better feel for what's happening during the winter months, so maybe January would be better.
we could also modify, you also could hear it in November and then continue it till January
All
as
right, so
well.
it seems like you want it in November.
Yeah, I would suggest
All right.
November.
It's,
Okay. All right, so the motion is by Jonathan to bring them back in November. Do I have a second?
I think Elizabeth already seconded.
Oh, okay. All in favor?
Aye.
Aye. Anyone opposed? All right, see you in November.
Thank you. For the record, that's the November 26th meeting.
No.
No.
It just got modified again.
All right, new applications, planning board filed PB 240705, mechanical parking at 1901 Collins Avenue.
The next item on the agenda is PB 24-0705, 1901 Collins Ave, mechanical parking. An application has been filed requesting conditional use approval for mechanical parking pursuant to Chapter 2, Article 5, Section 2.52, and Chapter 5, Article 2, Section 5211F of the Miami Beach Resiliency Code.
So just to provide some additional information on this, the existing site includes a redevelopment of the property, the Short Club property, including a new loading and service building on the south side of 20th Street. This will include a puzzle type of mechanical parking system for 7 spaces, as well as 4 tandem spaces, one ADA space, and 1 space for maneuverability. Because of the location here, it does require that the planning board review this type of mechanical parking, and that's why it's before you today. We do believe that it's not going to result in any impact on the neighbors or surrounding area due to the minimal nature of the number of parking spaces. We did pass out and email you a transportation memo, including some additional recommendations of conditions to be included in the draft final order. So we are recommending that the board approve this application for mechanical parking, including the conditions that are included in the recommendation from the Transportation Department. I'll turn it over for the applicant for their presentation.
Good afternoon, Nicholas Rodriguez, Burke, Del Fernandez, Larkin, and Tapia.
Real quick before you
Yes.
start, any disclosures on this by the board? No, none? Okay, sorry, go ahead.
No worries. Nicholas Rodriguez, Burke, Del Fernandez, Larkin, and Tapinas, 200 South Biscayne Boulevard, here representing the Short Club Property Owner LLC. We do have a digital presentation, if we could just call that up. Thank you so much. So I'm joined here from ownership by Adam Gottlieb, our project architect, Matt Picard, and our traffic engineer, Adrian Debkowski, is also joining us via Zoom. If we could, I have the slides. So just to give you an idea of this property, and as Michael Belush explained, this property was a subject of a redevelopment. It's currently in permitting. They're moving forward. The property is at 1901 Collins Avenue, just south of the Setai and 20th Street, just north of the Nautilus Hotel. It's a 3-acre oceanfront site. It was previously developed with a 200-plus hotel, and it is subsequently being redeveloped with a much less intense use. To get a little bit more specific as to the various structures on the property, it's a mix of contributing historic structures and non-contributing structures. A, B, and C are the contributing historic structures. It's the original Short Club building, A and C. And then B on the diagram is the Cromwell building. It used to be a separate hotel, but it was aggregated into the site, and that's the building that's on 20th Street, just to orient you. And then the building in the center is known as the Chipperfield Addition. It was added in the late 90s and early 2000s. That building is being demolished and replaced with the condominium tower that was approved by the HPB in 2022. And actually, they've actually done quite a ways of demolishing that tower. When you drive by the site, it's no longer visible. They're finishing up demolition of that to actually put in the new building soon. So with respect to the approved project, it was approved at 80 residential units and 110 hotel keys, which was a substantial reduction from the 200-plus hotel rooms that existed there previously. The version of the project that's actually going forward to permitting is even less intense. It's only 49 residential units and 76 hotel rooms. So it's a really low-intensity operation, especially when considering the fact that it's a 3-acre oceanfront site. Here's a rendering where you see the new condominium tower at the center of the site behind the original Short Club building.
Just so I understand, sorry about going through it, why the reduction in units and keys?
I think it was larger unit sizes and larger hotel room sizes. It's the same floor area, it's the same building that was approved. It's just what the market dictated was larger units. And so here, just to give you guys updated renderings of where they're at, some of their marketing materials. The building has been very well received, and our understanding is it's sales are going well. I believe most of the units are sold, and we're looking forward to getting this project off the ground. But one of the issues is, of course, parking in this area. So the original parking layout included a subterranean garage throughout the site. When this project went forward to the engineering phase after getting approved by HPB, it became apparent that the construction of this subterranean garage was going to have significant adverse impacts to the foundations of the historic buildings. I was really going to place the original Short Club building and the Cromwell building at risk when they had to build the ramp to get down into the garage level. So what has happened is most of the required parking is going to be satisfied off-site, and I have a slide on that so we can cover that. But what we're asking for is really just a much reduced ground level parking garage, rather than this expansive underground parking garage that was, nothing is infeasible, but it was going to create a substantial risk and have a significant cost that was making the project difficult to get off the ground. So the proposed garage plan, and we'll spend a little bit of time, as Michael mentioned, it's 12 total spaces, 7 mechanical spaces, 1 ADA space, and then 4 tandem spaces. And the reality is these spaces are going to be more of a luxury amenity than day-to-day parking for the residents. This is really just extra parking for people's, luxury cars or that sort of thing. It's not meant to be a day-to-day person's in and out parking, arrangement. You can see on the floor plan on the right, that is the lower level of the garage. On the left-hand side is where the mechanical parking puzzle system would be located. And that system would be 2-tiered, so that's the ground level, and then it would go one below. And on the left side of the image, that's where you see the lower level. So 7 spaces in a puzzle system, and then 4 tandem spaces at the bottom of the image on the floor plan. It's a little bit easier to see when you show it in 3D. Actually, the top level of this structure is a loading dock, and then the lower level you see in that section image is where the mechanical parking will be located. And just for good measure, this building is a separate new construction building that's being added to the site. It's going to have a green roof, be surrounded by landscaping. It looks quite nice for a loading and parking structure. So the way the puzzle system works, this shows 3 levels. It's actually we're proposing 2 levels. This is the manufacturer spec. There's always 1 space left open so that the system can scoot over and slide over and allow the car that needs to be removed to be lifted to the ground level, and then it just backs out of the space like a normal parking space. And here you can visualize what those mechanical parking lifts will look like in this garage. It's a reputable manufacturer that has placed other mechanical parking systems in Miami Beach already, so they're a local manufacturer. Here is the renderings of what the loading and parking building will look like. On the left is the ramp that will go down to the parking level. On the right is our loading dock. As you can see, the green roof and substantial landscaping. So another view from 20th Street. And then this is showing our off-site parking arrangement. So the majority of the residential parking requirement will occur off-site at 2000 Collins Avenue. And we've done a valet analysis to show how that will work and to ensure that we're going to have enough valet attendants to make it work. Only a small number of vehicles will actually.
What's it, 2000 Collins?
2000 Collins.
Is it a garage?
So we're Sweet Liberty,
Right.
Joe and the Juice is. There's
Right, but you said that's where the parking, what is there, a garage?
Yeah.
Oh, there is?
There's
Okay.
a large garage.
It's a
there.
city garage?
No.
Oh, it's a private garage? Okay.
Right, so they've negotiated with the owner of that property to basically purchase 100 surplus spaces in the garage and make those permanently available for the residences. So
I'm
only,
just curious, does the owner of that lot need one of those underutilized parking CUPs or anything like that? I'm just curious, because it's coming up in another issue.
Depends on the zoning district and the hours.
Okay, this one doesn't, they can just make a deal with
I don't know the particulars about this property here in that agreement, but,
okay.
yeah,
All right. No concerns from
So-
staff, though.
yeah, they have a significant surplus, so typically underutilized is like when you.
Yeah, no, I just know that certain garages, if they're gonna allow parking from other venues because they're underutilized, they have to have a special CUP,
so
right?
it depends. Sometimes if there's a condition in the original CUP that could prohibit that, then that could be a concern, but we'll have to take a look at that.
Okay, all right, sorry, go ahead.
Through the process of getting.
Yeah,
the
no,
outside-
I love having underutilized garages be used, so, but my understanding was that sometimes
And
it
I
has
do
to
know
be.
the garage next door to it does have an underutilized arrangement because they have so much excess parking. Although technically it satisfied the parking requirements, they substantiated that the parking, there's an abundance of parking there because people are not needing it to go to venues there.
Yeah, okay.
So, Nick, do you have a slide that outlines your required parking for this project?
So, no, but I don't have a slide on it, but I can tell you 49 residential units, they're all over 1,200 square feet, so it's 2 spaces per unit. Everything in the historic structure is exempt from parking requirement, except for outdoor seating. But we're not here today on their outdoor seating plan or any of their food and beverage component. When that does come forward, they're gonna need to either pay into the fee and lieu program, or use any of the various methods in the code to satisfy the parking requirement. But the residential parking requirement is all being satisfied off-site. So it's 100 spaces, 49 units times 2, 98 space requirement. They have 100 spaces.
Do you have any concerns with rust or any of that kind of thing? Because I know there's, I think, 3 parking, mechanical parking garages, maybe 2. I think the Satai has one, and they've had significant issues with rust and things like that. How are you dealing with that? I don't want somebody to be without parking. I just want to make sure that it's functional.
Right, so we're working with the manufacturer who has installed successfully in other buildings. They're a local manufacturer, so they know the South Florida conditions. I think they're building them actually here in somewhere in Hialeah. So that, you know,
They've
it is
just
a
had
concern.
issues, and I want to make sure that everything works really well.
Right, right. And again, coming back to, it's not kind of their day-to-day parking, right? Someone's, you know, Ferrari might be in this garage and,
Okay.
you know, if they have to, hopefully they never have to wait an extra hour for it.
Their car probably is
but
going to have
yeah.
more problems
Yeah.
than
Yeah, there already is. So there are already maintenance conditions required in the code.
Thank you.
And in the order.
And while I'm asking about it, do you agree with all the conditions in the proposed?
I'll get to that. We have a
All
few
right.
conditions that we want to work on
All
a
right.
little bit, so that's actually next. So staff has proposed a condition limiting our hours of loading at the loading dock from 9 a.m. to 4 p.m. We completely understand this condition in relation to conditional use permits for food and beverage venues. Our only request today is mechanical parking. We didn't intend to put the loading dock on, you know, to be considered here today. We are not the hotel operator, and at some point, the hotel operator will be coming before you for their CUP to activate the food and beverage, and we think it's more appropriate for them to have the limits on the loading hours and operations. This condition really has no rational relationship to our application request today, so we would submit that.
Would this bind the hotel operator?
We're applying these conditions to the entire property. And right now, there's nothing that would, if the property doesn't exceed a venue that's over, say, $199 with entertainment or $299 with entertainment, they're not required to come before the planning board. Actually, with a recent modification for restaurant and supper clubs, they may have to come to the planning board for any entertainment on the property. But there's conceivably a case where they don't come to the planning board. So that's why we included these conditions.
Well, I mean, that seems like a normal time frame, 9 to 4. Why would that be a concern?
We're not the hotel operator, and there is it's going to be an Alberge resort, and we haven't discussed this condition with them, so we don't know whether they agree
It's all
to
one,
it.
we're looking at this as one property, so
No, I understand. What are typical timeframes for deliveries and waste?
that's typical for this area to avoid the.
Other
the rush
hotels,
hour.
same
Yes.
restriction?
Yeah, I looked at some other ones. This is consistent with other operators along Collins Avenue.
And
Right,
we've
so
seen-
let me ask you, so his point is wait for the hotel, well, you're saying they wouldn't necessarily come before us.
Correct.
I see. So if we don't put it in here and they don't come before us,
You
then,
may want, you could include a condition unless superseded by a subsequent application, you know, so I understand a
well, in other
concern
words, if we
regarding-
didn't put it in here and they didn't come before us, they'd have unlimited
Right.
times. Well, we don't want that.
I mean, are you willing to come back to propose, you know, like before the hotel has their, you know who the hotel is or their operations plan? I mean, I guess our point is, listen, I mean, if you come to us and say, I need 8:30, I don't think that's gonna be,
I mean, I wouldn't mind amending the condition to make it clear that, you know, these conditions apply unless, if there's an application made to the board for an NIE on the property.
Right.
then those
They
conditions
can,
would
they can
apply.
seek a
And
modification.
this wouldn't require, no, we could draft the conditions so that it doesn't require modification of this. That any subsequent CUP for the property would supersede these conditions.
Okay, that's
regarding
fair.
loading, yeah.
Okay. That way, if they come before us, then, and we change the CUP, it'll supersede this. So let's go with that.
I think that's fair. Let me,
Yeah.
let me discuss with the client and make sure that they're okay with
Okay.
that. So, one moment. Yes. Yes, okay with that.
Yeah, Michael,
Yeah,
if they
we can
come
accept-
back and we do a new CUP and we decide to give you different hours, then it'll supersede this.
So you-
This is just in the event you all don't come before us because you don't trigger the requirement for a CUP.
Understood, but it just, 9 seems late in the day, and I was just wondering if we can have, instead of having no condition, could we have a counter condition? That'd be like 7 AM, and then, because I understand anything before 7 AM is crazy, but at 7 AM, that's when a lot of loading or deliveries
Well, that's why I
occurs.
asked Michael what's customary.
I don't know that 9 AM is customary.
I've seen it for other hotels along here. I mean,
Have you seen any with 7?
we probably don't want to go earlier than 7 because
No,
of the
right.
noise
Seven's cool.
implication.
Right, but is 7 palatable to the city?
No, earlier than 7.
Right?
Well,
But
I mean,
7's
to me, especially since there's hotel guests and there's other 7 seems early, but I'm not opposed to it if there's a plan to minimize disruption, if there's, the parking is clear, you know, the flow of traffic is clear, and so I guess the point is, well, I think we all want to sort of leave it open. If they need 7, come, let's talk about it, of, you know, how that's gonna work in, you know,
So
logistically.
we do have a condition here that requires them to come back to the board 6 months after operation to sort of update the board on how the loading and traffic and mechanical parking has been operating. So I think if we modify it to 7, that can be looked at the time of a progress report, as well as, you know, we have a protection that we are asking for a dock master to be there. So that also helps to maintain the operations.
Right.
Yeah, we were gonna mention the dock master, and that was something actually that we offered to transportation.
And just so you all know, like, the idea that we can circumvent your review when it comes to the food and beverage venues is not realistic, because the way the patron occupant load is calculated, you aggregate together the venues within a hotel. And the way they calculate the patron occupant load, they include circulation pass within each restaurant. So while you think like Catch Restaurant is a rather small restaurant, it zoomed right past the trigger needed for a CUP. And so I would just ask that 7 AM be good, and we'll come back and we'll modify it if necessary, but I think 7 AM is a good time.
If the board agrees, that's fine.
You okay with that?
With the provisions that we have regarding the dock master and
Yeah, that's fine, and
Okay.
7 AM with the ability to administratively supersede it if.
Right, so if
it's
there, if
superseded
there's
by
a,
another CUP.
a CUP application
Right,
for the property, and as part of that, the board says, hey, wait, we really need to move that to 8 or 9 now, then that would supersede.
I just want to say that I believe that the trucks are going to be backing in to your loading dock, and 7 AM, there are other residential buildings nearby. The backup, the beep, beep, beep could be problematic.
We could do no earlier than 8 on the weekends, or something that we discussed. So that's something that, like Catch that Michael mentioned, has on a limit on the weekends. It's just not typical, we don't think, to limit loading on the weekdays. The garbage truck comes through my neighborhood at 7 AM every day, certainly, and I live on Bell Island.
I just wanted everyone's radar, that's
Yeah.
all.
Yeah.
It could be
By the way,
problematic.
is there anyone on Zoom to speak on this?
We do have somebody on Zoom, yes, but did
All
you
right,
finish
hold
your
on.
presentation?
Are you
No, we're not
finished?
done. All done.
Okay,
Yeah.
hold on. Go ahead.
So I think that takes care of the majority of it. There's one other condition related to, the staff had recommended keeping one of our only 12 parking spaces for circulation and maneuverability. We do have Adrian online, and we did upload a maneuverability analysis that shows we can maneuver within our garage even if all the spaces are full. So I don't think we really would not want to lose one of our only 12 spaces to keep it for valet circulation, when clearly we can maneuver within the garage without impacting the right-of-way. So if the concern is that we're going to impact the right-of-way, we'll just prohibit impacting the right-of-way without being prescriptive as to requiring us to keep one of our spaces open. It's only 12 spaces, and it's limited.
Well, as long as we prohibit it, that sounds fair.
Right.
Okay.
And then this was on 10C, we just want to make sure we coordinate 10C and 3A, because there's another condition that says loading should be limited to non-peak hours. So whatever 3A says, 10C should say the same thing.
Right, Michael? Agree
Okay,
with that?
got it.
Okay.
So with that, that's all we've got, and we respectfully request your approval team's here for questions.
Okay.
Thanks so much.
All right, who's on Zoom?
So we have Kent Robbins on Zoom with his hand raised. Kent?
Here we go. This is a tie. Kent? Kent, you there?
Hello, this is Kent Robbins.
Have you been sworn in?
Thank you for taking my.
Huh?
Do you hear me?
So?
Yes, this is
Yes.
Kent
They lie
Robbins.
more
Kent,
than-
Kent, I know you're an attorney, but do you swear or affirm that any testimony you provide is the truth, the whole truth, and nothing but the truth?
I appear as an attorney. I represent the Satai Condominium Association, immediately across the street. There's a couple concerns we have. It's already been raised about the backing up of trucks. Remember, we have over 100 residential units across the street, and the backing up of trucks does disturb the residents in the morning. We would ask that we have a cutoff that they cannot back up before 8 a.m. in the morning. And then also that be considered at the time of the 6-month follow-up to see whether or not there's sufficient, whether or not that is disturbing our residents between 9 and 8 to the extent that it's unbearable to them. If it's unbearable, obviously we need to then adjust it again. But I ask that we have an 8 a.m. Start time as far as loading and unloading. The other question I have is, originally the parking was on site. I just want to have an understanding, the presentation was not clear. How many residential parking spaces were on the site that now have been removed from being on-site parking? Number one. And how are we handling the valeting of those new cars that would normally have been parked on site and now are going to have to go through the valet process? So that's a question to, I guess, to the transportation representative of the Shore Club.
So, Kent, do you want to finish your comments and then we can have the applicant respond?
Okay, so our concern of that is, I really need the answers to that to be able to make further comments, because there is substantial testimony and issues involving the valet and handling of the valet, and it had been represented that all the parking at the HPB, that all the parking would be on site, that the valet would park it and enter right into the building, and we would not be impacted by valet coming in and out of 20th Street. Now this is an entirely new plan being presented. So number one, I want to know how many residential parking spaces were originally approved. My understanding that there was there was sufficient parking for all residential parking on site, and now that's being removed. How are you sufficiently handling the valet so the valet will not interrupt 20th Street? As everybody knows, 20th Street is only 2 lanes, and that serves the Satai, it serves the Art Deco Hotel on 20th Street, the Satai Art Deco Hotel, and it also serves the residential tower, and that entryway is on 20th Street. And it was a very carefully planned on how valet would be serving the 20th Street area. Now with the change in plans, we do not really understand what is the change, how are they handling the new valet requirements, and how are they handling the queuing of cars on 20th Street. We had been assured that there was sufficient parking on site, so the cars would be immediately be taken off of 20th Street and parked within the area. In fact, it was arranged originally that the cars would literally drive into the parking garage underground, and then the valet would then take it from the underground parking area and then park it itself. Now it appears that those cars are going to be left on 20th Street and then taken by the valet and then taken wherever it is. So the issue is how many parking spaces are now being reduced from what was originally planned? And how are you handling the queuing of parking, given that's only a 2-lane road and there isn't sufficient, if the cars start to queue up, there will not be sufficient space. And should the 20th Street be blocked as you enter into 20th Street going going eastbound. That will block the entryway to our parking garage. And that serves literally hundreds and hundreds of cars. So I'd like that to be explained on the record.
Yeah, you want to answer that?
So first, I mean, the off-site parking is not the subject of today's application, but we have submitted a revised traffic study. The Transportation Department has a memo that is included with your staff report that evaluated our valet operations, exactly how many attendants we need, and confirmed that queuing is not going to be a problem on 20th Street. We also have a condition that within 6 months of the project becoming operational, we're going to come back with a new study and confirm that queuing on 20th Street is not an issue. Again, also, the intensity of our project has been substantially reduced. Only 49 residential units and 76 hotel rooms on a 3-acre site. We did reduce the parking from the original approved plan. There's only 12 spaces now, and there was close to 75 before, but it's because of the impact to the historic structures, and we're doing everything we can with the Transportation Department to ensure that there are no issues on 20th Street for the Sentai.
Thank you. And Michael and Nick, I think Nick raises a good question. What is the question in front of us today? And if the off-site parking is not in front of us, who has jurisdiction over that change?
Well, I think here that the valet parking was included and was reviewed by the city and transportation staff as part of this application. So we did include a transportation memo. It was emailed to the board members and passed out this morning. This does indicate, the valet for both the hotel portion and uses and the residential portion. And as indicated in the transportation memo, which references the traffic study, there would be 10 valet attendants for the hotel restaurant valet area required and 3 for the residential valet drop-off area. And so that's something that was reviewed as part of this analysis. When the application for mechanical parking or an NIE, the Transportation Department does look specifically at any valet operations, and because this was made as part of this application, it's something that the Transportation Department did take a look at. So that is referenced in our application, and as part of the applicant's application, I believe they did include a floor plan of what was previously proposed that shows the parking that was on site previously, correct?
Yeah, correct.
Do you have a reference to what sheet that is in the board application?
And in the actual plans or in our presentation, I have it.
For the HP board certificate of appropriateness, did they consider off-site parking as well?
The board doesn't get in, the HPB doesn't
Okay.
technically get into those operational issues. Now that this is coming before the planning board, the board can look at that valet operations and the valet analysis. But it wouldn't require going back to the Historic Preservation Board if they modified the parking requirements. They could also, like, for example, they could pay fully into the fee and lieu program, not provide any parking on the entire site if they so wish. And that wouldn't require a modification of the HPV or even the planning board. If they decided to after this, they could decide, hey, we're going to pay the fee for all the parking, and it wouldn't have to come back to the planning board.
So legally, how does acquiring parking spaces in a off-site garage, how does that work?
Well, there has to be a long-term lease arrangement. There's a whole section in the code that talks about the distance. It has to be within a certain distance requirement. And there's a whole section of the code that references those requirements.
But in addition, we had to substantiate that the garage had surplus parking and analyze every single use in that building and make sure that those spaces were surplus, provide the proof to the city, and then execute a covenant against the property so that it's known that those spaces are permanently.
These parking spaces are essentially reserved for that use, forever.
And that's been done or
Yes.
will be done? Okay, thank you.
Anything for you?
Do you want to give a chance for Mr. Robbins to respond?
Sure. Kent?
Thank you. Here is now a reduction of 75 on on-site spaces on the lot that was previously approved by the HPB. And at that time, there was a critical issue involving how the traffic would be removed from the site. Apparently, there is no demonstration that there is sufficient lanes available to be able to handle this additional valet use before the 75 parking spaces would accommodate all the residential use on site. So we did not have a concern about valet because the valet was being actually handled within the parking lot itself, and the driver would drive into the parking lot, and then the valet would take over from inside and underneath the building. That is a substantial change. Now, you're talking about a transportation memo. That transportation memo was not online yesterday, and
Yes, it was.
apparently you're
I
acknowledging,
downloaded it and printed it.
well, it's not online right now, the transportation memo. It's not online right now for this meeting, and you're saying it was delivered today to the board members. We have had insufficient information to be able to evaluate the information that's being presented to the board, and we're really being denied due process. We, the Satai, are being directly impacted, and this is 20th Street is the only means of egress to our garage, which serves not just the tower, but also the hotel in front of the tower on Collins Avenue. We are very concerned that this 20th Street, which has been a very tight, very difficult, very tight area to serve the two hotels, are now going to have this additional burden of LA parking, 68 more parking spaces off-site. And the time to service that, and there's no showing that the valet is going to occur any place on the street other than on the street, I think that issue has to be evaluated. To say that a memo was provided this morning is not sufficient time for me to sit down with my experts to be able to discuss that issue.
Mr.
So
Chairman,
I'd ask that
can I
you-
respond? Does he have a time limit?
You finished, Kent?
Yes, I've made my objection. I'd ask for this matter to be continued in order for us to have a chance to read this transportation memo that has been presented to you, which has not been provided to us as a matter of due process, and allow us to confer with the developer. I'm sure that if we have time to discuss, we can figure out a mutually amicable resolution. But this should not be shoved down the throats of the neighbor without adequate disclosure to us. They know I'm the attorney of record, and it was never provided to me, and this memo was not provided to me. So it's very upsetting that this is being done without
So-
at least
Thank you,
giving
Ken.
information.
So, Mr. Chairman, as you know, they're actively litigating against us. We've always maintained that the Satai as an association has no standing. If you listen to what Kent was saying, he's saying he's here representing the association, not individual owners. And we maintain that association has no standing. Association cannot prove damage that's specific to them that's greater than to the general neighborhood. That's the standing under Renard, which is the seminal case that governs throughout the state of Florida on standing and zoning issues. Second, his opinion testimony is merely that. It's layperson testimony. You have a memorandum from your transportation department that constitutes substantial competent evidence. I don't know where Kent was yesterday or the day before, but this memo was available. His procedural due process rights have not been violated, and we respectfully request your approval today.
Any questions?
Nope.
Anybody want to make a motion?
Motion to approve?
Okay, do we have a second?
And so you're approving with
I
their
I would
proposed
approve it with
modifications.
their proposed modifications, with the hope that when they come back after 6 months, we'll be able to see how it's working and modify if necessary.
And with the loading condition that was discussed on the record.
I'm gonna, so we had included some recommended conditions from transportation as part of our draft CUP. We have a couple additional modifications that are recommended by the Transportation Department. So I want to read those into the record and make sure those are also incorporated into the order, which would include, the applicant shall coordinate with the City of Miami Beach Transportation and Mobility Department to implement an acceptable transportation demand management implementation plan for the TDM strategies outlined in the most recent traffic impact assessment prior to the issuance of building permit, as well as the applicant is required to provide a signed copy of the valet parking agreement and covenant between the applicant and the property owner at 237 20th Street prior to the issuance of a building permit, and this should reflect the final allocation of the 100 parking spaces, 4 on level 3 and 96 on level 4. We already had a condition regarding the requirement for a loading dock master to oversee the movements. And then an additional condition, the applicant shall provide updated mechanical specification cut sheets to the city for the final vendor for the semi-automatic puzzle mechanical lift parking technology, if different than the vendor used in the valet parking operational analysis. And then,
Accepted.
does the board want to discuss, I know that there's been some discussion now regarding the hours for loading. We had initially recommended 9 a.m. There was a discussion regarding 7 a.m. during the week and 8 a.m. on the weekends. What is the motion to include for the hours for loading?
I think it's sensible to consider the residents around there. So I think if we go for the 8, which was Ken was proposing, 8 across the board for week and weekends, and if there's an issue with the new restaurant or they can come back in front of the board. And I think we kind of find peace there.
I would put 8,
Right.
8 a.m.
So the loading operations will be 8 a.m. 7 days a week, not
7 days a
before,
week.
Correct.
to 4 p.m., correct?
8 a.m. to 4 p.m. And then if there's an issue, either they come back or they will be back either way after 6 months.
That's fine.
All right, yeah.
Who made that motion?
Sorry?
I did.
Lucille. So
And-
I need a second. Okay, Jonathan second.
All in favor?
Aye. Anyone opposed?
I'm going to vote yes, but I do have some concerns that were raised by the neighbors with regards to 20th Street. It's a really beautiful street. It has a great tree canopy. And I just hope that if there are any changes made to address some of these concerns of queuing, that the trees are preserved along this
yeah.
street. It makes for a beautiful pedestrian experience.
Yeah, we wouldn't do that.
We're
Wouldn't
adding
leave the trees.
landscaping around our loading area, not removing any trees.
Yeah, we're not hearing that today. Thank you.
Thank you.
All right. Thank you all very
All
much.
right.
Appreciate it.
Everyone, it's a good time to break your lunches here. We'll take 15 or 20 minutes. All righty.
Please take your seats. The meeting is about to begin. Remember to speak into the microphone, as this meeting is being recorded for public record. Please stand by. We are going on air in 5, 4, 3, 2, 1.
Okay, welcome back, everybody. Thanks for giving us time for lunch. Moving on, we are on to comprehensive plan and code amendments. The next two are companion items, Planning Board File 240709 and Planning Board File 240710, both dealing with Canopy Park Comprehensive Plan, Flume amendments, and zoning district changes.
Thank you. I'll just go through some brief history for these amendments, and then also point you guys to the maps that we have, starting on page 6, 7, and 8 of the staff report, so you can get a better understanding of our existing maps and what's proposed. So as part of the development agreement for the 500 Alton Road project, the developer designed, constructed, and conveyed a 3-acre public park to the city of Miami Beach. This is the property located at 701 West Avenue. This is a municipal park operated by the city for the benefit of the general public. And on August 23rd of 2020, 82% of the city voters voted to name the park as Canopy Park, and that's how it's referenced in our report. Now, as proposed, these subject ordinances include the rezoning of Canopy Park, as well as a reclassification of the future land use designation on the city's future land use map to better reflect the change in ownership of the property and use as a public park. Currently, on our zoning map and future land use map, these are both designated as CD2, which is commercial medium intensity, which is the zoning and future land use classification at the time of the original development. These subject ordinances would change the zoning district to GU, government use, which is the classification now that the city owns the property, and would change the future land use classification to ROS, which is recreation and open space. On page 6 of the board packages, you can see the area outlined in red. That's the area specifically of Canopy Park that denotes the 3 acres and the current zoning of CD2 and future land use of CD2. And as proposed, this would change the area of the park to GU, government use. The surrounding zoning districts would remain as is. And on page 8, you can see would change the future land use to recreation, open space. And as indicated in our report, we provided the land use classifications, including the prior land use of CD2, as well as the proposed future land use of ROS. You can see the purpose and uses which are part of that change. We are recommending that the planning board transmit both these ordinances to the city commission with favorable recommendations.
So this is essentially just a formality?
Correct. If the board did nothing, the zoning district does change automatically to GU, but there's nothing that automatically changes the future land use classification, because it could be ROS, it could be PF, which is public facility, it could be something else. This sort of denotes it as recreation open space versus having the ability to construct, public services and things on the park property.
Okay.
And I don't see anybody on the
No one on
public.
Zoom?
And no one on Zoom with their hand raised.
Okay, no one here, obviously. So is there any questions or?
I just
motion
have
to
a
approve?
small question. What's that little sliver of the park, I guess you'll call it, that's north of the main parcel? The main
So
portion?
that was, the public perception at the time was that we need to create 3 acres. So this was done to get to that 3 acre threshold. That's the real reason why it was done.
Okay.
It does include, landscape areas along the western border of the park, but that's the reason why it was done, because the perception of 3 acres. And you'll see, it's exactly 3 acres, 3.000 acres.
So just to follow up, if that land is ever developed north of the park, that little sliver could not be part of that as well, right?
You're talking about the site that's the parking for the Floridian.
Yes.
Well, that remains as CD2, and I believe that FAR has all been transferred also as part of this.
I think, correct me if I'm wrong, but I think you're referring to the finger itself.
The finger itself.
Yeah.
which
Oh,
is-
correct, yes. Yeah, that area can never be developed.
Okay. Or even like build over, no cantilevers over there or anything? Or-
Well, it would be protected for a number of reasons. First of all, if you change the flume designation and the zoning map designation, I don't think that would permit any
think
sort of
so,
development.
right.
But also, as park property, it would be protected under the Miami Beach City Charter as well as the Miami-Dade County Charter.
Thank you, Nick and Mike.
One quick question, Michael, that the area of the, I still call it the park, where the sales center is for the condo building there, that's never, I mean, no, not going back to the park. I mean,
No.
that belongs to the building and
Right, that's going to be developed with a future retail component,
Retail,
which
okay.
FAR was allocated for that purpose.
Okay.
That may come back before you, because I believe they may want to change the design and functionality of that. That was previously approved, reviewed by planning board as well as the DRB. I've seen some proposals, but no application has been made yet to modify those plans.
Anyone want to make a motion?
Motion to approve?
Okay.
I'll second.
Okay, all in favor?
Aye.
Anyone opposed? Okay, that's for both items, right?
Correct.
Okay, great. All right, and then last item before our discussion item is Planning Board filed 240711 Unified Development Site LDR text amendments.
Just a second here. So this is related to the prior proposal because it does modify the requirements for unified development site to take into consideration what happened at the Canopy Park site. When the development creating Canopy Park was approved, the entire overlay was located within CPS2, CD2, and RM2 zoning districts, which all had a maximum FAR of 2.0. Now, all the available FAR for the portion of the site that is now a public park was moved to other parts of the site to accommodate the new residential tower and what we referenced as the detached retail structure. So this amendment, which is included on page 4 of the staff report, addresses that, what happened for the site by including the following. For unified development sites that are subject to the terms of a development agreement with the city of Miami Beach and contain properties with different zoning classifications, as well as properties located in the Alton Road Gateway area, as defined in section 7.2.11.7, the maximum allowable FAR may be distributed within the entirety of the unified development site in accordance with the provisions of the applicable development agreement. This doesn't change anything in the future going forward. This sort of just reconciles what happened in the past now that we have different zoning districts.
So this is like an after-the-fact approval.
Well, it's to address what happened as part of the rezoning that we're doing now. Right. And is there any public comment on this application?
Anyone on Zoom?
There's nobody on Zoom, and I see nobody in chambers.
Okay.
Motion to approve?
You get a second?
This would be to recommend in favor to the city
Yeah.
commission.
Second, someone? Okay, Scott seconded it. All in favor?
Aye.
Anyone opposed?
Motion passes 7-0 with a
Okay.
favorable recommendation.
All passes. All right, we're on to Resiliency Code Clarification Amendment discussion.
And PJ, if we can bring up the presentation?
Sorry, I have to deal with one quick work thing.
So just for some background on this, as referenced earlier in the meeting regarding changes to the code sections, I think it was June of last year where the city adopted our new resiliency code. So we're going to be bringing forward some clarifications and amendments. We've had over a year now to be working with the code and hear comments and concerns, in reviewing permits from architects, residents. And so the purpose of this discussion is to bring forward to the planning board changes we're going to be bringing forward as part of code changes to clarify a host of issues. Some of them are slightly substantial. Most of them are purely clarifications and just sort of codify how we have been interpreting the operation, implementation of the new resiliency code. So I'm just going to go through, if we can go, PJ, to the.
And sorry, just before you begin, I guess what are we voting on? Are we voting on anything?
No,
Is
you're
it
not
just a
voting on anything today.
discussion?
This is just a discussion.
And if we have questions, comments, or concerns, we bring it up and it can be modified? Or?
Yeah, we can bring it up. You can email me separately. It'll come back before you with a more comprehensive ordinance amendment. This is just to see if the planning board members have yourself experienced or heard of other experiences or concerns, and feel there's other areas that also need to be addressed as part of this update. So, PJ, if we can go to the next slide. So on this page, these are all just clarifications on definitions regarding where you take the side yard and front yard for a property that's a corner lot, clarifying what's a high albedo surface, cool pavement, just more clearly defining a lot within the code in terms of the applicable zoning versus the minimum requirements, just slight tweaks, nothing major with our proposed modifications or clarifications to the definitions. PJ, on the next, can you go to the next slide?
So we're not at the slightly substantial part yet, right?
There's nothing even slightly substantial with that.
Okay.
Under use clarifications, I think the board has you've seen applications for outdoor paddle courts, outdoor recreation, things in commercial districts. That's something that's not explicitly indicated in the code as an allowed use. So this amendment, as proposed, will be clarify that these outdoor recreation commercial facilities would be allowed in commercial districts. Typically, if there's a CUP or it involves changes to the overall building design, it likely would require coming to the planning board for approval as well as to the design review board, because it doesn't typically include the construction of taller fences and guards for the rooftop uses. But we are seeing a push for more of these types of uses, so this is to expressly codify. We have had to, we've responded by providing zoning letters to people to clarify, is this use allowed in this property? So this would make it clear that these sorts of commercial recreation uses would be allowed in commercial districts. We also would be clarifying that nuisance uses such as occult sciences or tattoo parlors, smoke shops, things like that, would not be allowed in residential districts. In the geo district, we're going to clarify the allowable government uses, and also sort of tighten up the industrial uses and auto-related uses in the industrial district. Right now, typically, only if you want to do like a car wash, that's only allowed in the I-1 district. It's not specifically in the code, but it should be, unless you're doing like car wash that's accessory to a gas station, but that does require, a CUP and a whole other host of implementations in order to add or modify accessory uses to a gas station. In terms of hotel occupancy limits, right now, there are limits for hotel occupancies in the residential districts, including the RPS, RM1 to RM3 district. This would also include occupancy limits for the CPS1 and MXE districts. In terms of, if you go to the next page, PJ, under yard encroachments, one of the things that it is a code change, more substantial, is modifying the allowance for central air conditioners and emergency generators and pool equipment and that type of mechanical use as allowable yard encroachments in all districts. Right now, technically, those encroachments are only allowed in the RM1 and townhouse district, as well as were mentioned in the single-family district. So for all other districts, those are not specifically allowed as allowable encroachments. So if you're in an RM2 district and your building meets the setback requirements, then you would have an issue with trying to add or incorporate air conditioning into your side yard. This would allow this, because right now, let's say you wanted to install such a unit, if you're in an RM1 district or townhouse unit, you can do that with a 5-foot setback. So this sort of would allow that setback to be implemented for other districts as well. Right now, we clarify that bicycle parking is an allowable yard encroachment, 25%. We're applying that now, and in our code, it's just not specifically in the code. So this would include that, as well as art installations, allow them as yard encroachments in non-single family districts, subject to design review approval or a certificate of appropriateness. terms of our limits on accessory buildings and walkways, the code has a requirement now that says 70% of your required yard must be pervious landscape area. You're allowed to build 30% for a building. This would just clarify that 30% also includes walkways, because you also have that requirement that you have to maintain 70% pervious landscaping, and walkways do not count as pervious landscaping. This would also clarify the setback requirements for projections, for marine projections. Right now, we have a setback of 7.5 foot on either side for the docks. Just to clarify, this extends out into the waterway. And then we just clarify that mostly these marine structures now are reviewed by the county. I don't know if some of you may remember, maybe Brian, we used to have a lot of docks appear before the planning board if they were going beyond a certain projection. Now that is all subject to Durham, so we no longer review those types of applications. It's a simple process as long as they meet the county requirements, not asking for any variances. This clarifies how we're operating currently with that. Next
Michael,
slide.
before you go on,
Sure.
your, central AC units, generators, if they're going to be in the exceed the setback, would they still need a variance?
No, this would
This
would
would
allow
allow
them
that
with a 5-foot
without-
setback.
all
But
right.
there's also a requirement to have screening, so.
Well, that was gonna be my concern, because a lot of times, you have maybe a new home going in front of a board, and, they decide to put a generator or an AC unit very close to the bedroom window of the property next door, and it gives the neighbors an opportunity to contest that.
Well, right now,
that's-
so that we're not changing that for single family. That's in the code right now. You can do, if you meet certain provisions. So it's not just as of right, you get that 5-foot setback. You have to be no higher than a certain location. So you can't have your AC unit higher than, I think it's 10 feet from grade, because the building code requires you to place your equipment at a minimum elevation of the base flood elevation. So typically, if you were going to do these types of mechanical equipment or AC units that comply with the code, you're looking at a shorter height to the AC unit.
It's more location, where they're at, not so much off the ground, how high off the ground. I know it's something you may want to look at, how you can kind of just
Yeah, we can.
prevent conflicts like that may come up with that.
Well, I
May
think
come
we-
up with people being allowed to put a generator or something maybe too close to somebody else's property, or,
Yeah, and typically, right now, I think what's going to be included in this provision is a certain limit for the size. So that's why right now, you don't see a lot of generators meeting this requirement because they're too tall, and based upon the height, they wouldn't comply. So I think, I agree, tightening up those requirements. So if we are going to allow any type of mechanical equipment or generator at that setback, that it be under a certain set of strict
Yeah, I
provisions.
mean, I want to see things are simplified for applicants, but you don't want to have something so simple that you can put it anywhere right next to
Right.
somebody's bedroom window. So, yeah, I mean, as long as some thought it goes into that.
Yeah, I think the intention is this would be more for the ground level versus, vertically up an entire building.
And will they have to be elevated off the ground?
But that's a code requirement by building, yes.
Okay, I just checking.
Do we have a special speaker on this?
Just wants to check in. Make
Glad
sure
to see,
everything is
I haven't
functioning
seen,
as it
I'm
should.
just glad to see you not on a bicycle. It's nice. Go ahead, sorry. I thought maybe you're going to speak. Go ahead, Michael.
Okay, if we
sorry.
can go to the next page, PJ. So right now, we have implemented a planning and zoning permit, so this is for elements that don't require a building permit. This just defines that in our resiliency code, just to specify which activities can be done with a planning and zoning permit versus a building permit. Also clarify that a paint permit's not required when painting up to 25%.
Is this just for like a building, or it also applies to a residential house?
This applies to, I think this applies more to commercial property or multifamily property in terms of the painting.
But that's specified?
Yes.
Okay, so if someone wants to paint their house,
We don't
Very
regulate
good.
that now, right?
you never know. Thank you.
we can go to the next page, PJ. So this is more just clarifications for single-family districts. A lot of this are items that were specifically included in the prior code, and through some oversight or whatnot, wasn't specifically called out or not as clear. So first is to clarify that when the code references a single-story structure, that means a maximum height of 18 feet for a flat roof and 21 feet for a sloped roof. So you can't come in and say, well, I'm doing a 27-foot tall sloped roof, but it's only 1 story. I don't have to comply with the 2-story setback requirement. So this just clarifies that requirement. This also just clarifies that pools and ponds can go within the understory area. Some clarifications on the setbacks. There's also a new requirement in the resiliency code to have a minimum ground floor clearance for single-family homes of 12 feet, but it doesn't specify from where. So we don't want to penalize somebody who's building their home, say to BFE plus 5, they're going above and beyond the minimum elevation, then require them on top of that to go 12 feet taller. So they're already building in that resiliency by building the higher freeboard. So this clarifies that 12 feet is measured from BFE plus 1 versus what they're actually building to. We're also clarifying or establishing that for architecturally significant homes, these are homes that administratively can take advantage of incentives such as increased lot coverage, increased unit size, reduced setbacks, as a condition for substantially preserving and retaining that structure, which is beneficial to the neighborhood. We're also proposing that the some of the side yard setbacks requirements would not apply to these architecturally significant homes. We also had a prior code allowance for porches and platforms in your front yard, and currently the code says that can only be 30 inches above the elevation of the lot. Of course, now that we're raising everything higher, that also has to go higher as well. So this just clarifies that that's allowed up to the first level to have your porch as an allowable encroachment. Also clarifies setbacks for pools. These are all how we're implementing and using the code right now. A 20-foot setback for a pool in the front yard, that applies to the pool or pool deck. You can't do, we've had people come in and say, well, I'm placing my pool water at 20-foot setback, but I have a walkway in front of it, not a pool deck. So that clarifies that both the pool and pool deck are part of that, the pool. Let's see. We can go to the next page, PJ. For the parking, we're just clarifying that, for example, for restaurant seating, restaurant areas, if the code requirement talks about the parking requirements per seating spaces, but if you have large areas for standing, that we calculate, areas such as dance floors or bars, that you don't have seats, that also requires a parking requirement. Not just, you just can't say, there's no seating there, there's no parking requirement. This sort of just formally establishes that there is a requirement for that. We already do this when there's a parking requirement and you come up with a fractional number that says like 10.1 spaces, you have to round up to the next highest number, or 11 in that case. Next page, PJ. Under hearing procedures and appeals, this just reconciles the quasi-judicial procedures in the resiliency code with chapter 2 of the city code, just to make sure there are no conflicts. So we have these requirements in 2 sections of the code. This is just to make sure that they're coordinated with each other. And we just replaced the special master, which is the term we were using, with special magistrate. Next page, PJ. And in terms of the amendment process, what this really does is just clarify the time frame for us to place an application, on the agenda for the planning board for code amendments. Right now, the time frame is pretty tight. Over time, the notice requirements have changed. If you go back, 15, 20 years ago, it was typically a 2-week notice for a lot of these applications. Now we do have a 30-day notice requirement, so meeting our Herald deadlines, can be an issue sometimes. I know that separately we're in the process of also amending the code to allow us to place the public advertisement not in the Herald, but in another website that also the county's using. So that's separate from this. But this is just to update our amendment process.
Is that governed by the state? Like, would it be possible to just have a Facebook post or a Twitter post just to get it going?
There are a lot of people that don't have that, though. I mean,
Oh,
especially.
but there are a lot of people who don't have the newspaper either.
Well,
That's why we're implementing, working on a different system that I think the county's using. Is that,
Yes, as to newspaper notices, and I believe the planning board has already
yeah,
voted
the
on
planning
that.
board recommended in favor of that. Was it last month? I think
It was last month to allow us to, instead of advertising notice of these meetings in the newspaper, to publish them online, which is what the city commission is also doing.
So, like, I remember when I had to go through my house process and I had to wait, I think it was 2 weeks or a month, whatever it was, because I had just missed the Herald cycle. So someone who's going through that process wouldn't have to wait, I guess.
We have a lot more
that time.
control, right?
They could do it instantaneously.
I'm sorry, it was the land use committee that endorsed it. It's
I was
coming
like,
to
I don't
planning
remember
board
that.
on October
Thank you.
29th. Sorry.
It's okay, I vote in favor of it.
oh, wait a minute, I'm going to.
Thanks, Tom.
I remember I advertised it for October. That's what it was. Okay. So I did also email this presentation to all the board members, so you have that as well. If we can go to the next page, PJ. For signage, this just clarifies that real estate signs do not require a planning and zoning permit. Signs still have to comply with the city code, and if a property owner installs a sign and doesn't meet the requirement, they can and should get a citation or violation.
Is this the time to talk about this, or?
Yeah,
No.
you can.
Okay, so our sign criteria, the minimum, it says the minimum is 11 by 14 notice. And when you go to any property, whether it's by the city or a real estate sign or whatever it is, you see these little tiny signs. It'll say, coming, two of these guys, coming, what is that? It's planted in a park, okay, that we're gonna be doing something. It says the minimum is 11 by 14. Every city, so the signage requirements that to clarify
I
the
think you're
minimum
talking,
is.
I think you're talking about the signage for a public application before the land use board, wanting to have the required
Any
the
of that,
size
I just
larger.
think that it needs to be included. I think we need to, if we're addressing signage, all of that, it needs to be, we can't have just, it says minimum. So all of these signs, they're huge. When you go by, Michelle, you can vouch for this. When you go by a public property that's being developed, it'll say.
Oh, you're talking
this-
about the signs that have all the commissioner names.
No, this is if it's being developed, so you
Right.
know what it is. So you don't have to go, exactly, so you don't have to go up to it and go, what is this? Why is it so small? We need to say this needs to be, the minimum needs to be moved up
For land use board applications.
for any, yes, or
Okay.
if something is gonna be done in a park, or if something is going to be,
So you're talking about, just to clarify, this would be for if there's a public meeting or announcement, you're talking about more for public announcements or what?
yes, so if you've got something like Allison Park or wherever there's gonna be, let's just use an example that, there's gonna be beach renourishment, okay? You've got a little tiny sign and you don't know what it is. And you have to pull over,
She's talking about on the property.
yes,
You're
on
talking
the
about like
property itself.
A public notice.
City, or developments, there's just tiny little signs, and you don't know what it is. You can't read it, and that there's just no way to know. So if we're gonna be amending the signage, if we're adding or clarifying signage, I think that should be included as well.
So increasing the size of the red notices you're talking about.
Those, as
Okay.
well as any,
And the other ones may not be governed by
it's in our code.
The other ones may not be governed by the LDRs, like when the city is publicizing a project that we're doing. Those may not be governed, like, for example, a beach renourishment. There may be other notices of that,
It says the minimum sign, the minimum.
Yeah.
is 11 by 14. That doesn't mean that we can't go larger so that people have more access to knowing what something says. So I'm just making that as a suggestion, because people don't know, it's this little tiny sign that's,
I would just say, just my 2 cents, but generally, the red signs that are posted are usually catch your attention, right? And so I'm not, either way, you'd have to come up and go read it. So if it's something that's of interest of you getting the information, you're gonna have to stop and go and read it anyways up close. It doesn't matter if it's an 11 by 14 or
but that's the whole
13 by
point,
16.
is when you've got the 11 by 14, you've got tiny little print. So then you're really having to stop. It needs to be something that the font size should be a minimum of,
And a lot of these notifications are like a full-blown letter. So, I mean, it's you're gonna need to, you can't do it where you gotta get out of your car and go read it.
That's the whole point, is you shouldn't have to.
Well, I mean, there's a lot of writing in these messages. If you're trying to put a full text, like most of those notifications are pretty full pages.
I mean, right now, our notifications, which are they're an 11 by 17 format right now. It's pretty much the full page, because we include all the legal requirements.
So
and-
make it larger and just maximize it so people can go, oh, okay, that's what that is. It's just,
I know, so and some cities use large, I know where I live in Miami Shores, it's like they do 24 by 36.
that's right.
Larger
just feel
size.
like
We
it
have to
should
take a
be-
look at the logistics right now. Our department, laminates those things, so we can easily do that and post them. If we're looking at a different process, we need to take a look at the logistics involved in looking at something else.
11 by 14 is awfully small to include a lot of information, and you actually have to park your car, get out, go look at it, and go, what is this? It just needs to be, I'd like to see that clarified as well, if that's.
It's something that we can take a look at.
Okay.
I think that was it in terms of the presentation.
So can we go back also to the marine, I guess it's projection?
Sure.
So there's a property on Pine Tree that is a historic, they've incorporated part of the historic structure into their new home. And there was a previous boathouse that projects out into the canal. So would this make it easier if it's no longer governed by the city? Would it make it, and it's governed by a county authority? Would it make it easier for somebody to say, oh, well, I'm going to apply to have a new boathouse and I don't have one
No.
now?
No,
Okay.
this, you would not, what's there today is so unique, you could not do
Okay.
in the future.
I just want to make sure.
Yeah, this does not affect
Because I
that.
think we all know that property, but I just want to make sure about that. I think there was something else too, so I don't know, y'all.
We did have a couple other modifications here. Paige, if you can bring up the presentation again. We're just going to be modifying the requirements to address requirements for architectural significance letters. These are formal determinations that staff does administratively. About a year or 2 years ago, there was a state requirement that says we can no longer treat pre-42 homes differently than post-42 homes. Prior to that, that change, we required a public notice that was sent out to neighbors and posted on the property when anybody came in for a formal determination of architectural significance. Now it's just something that's done administratively, because anybody taking advantage of this is not demolishing the building. That sort of was intended when an applicant wanted to demolish a building and required them to go to in front of the design review board. That's no longer the case now, so this just clarifies that requirement. And in terms of the Supper Club hours of operation, we're going to be fine-tuning some of those amendments and the hours.
What are those hours?
Tom, do you have an update on the Supper Club ordinance?
The hours, I believe, remain the same. It's going to the commission for second reading on October 30th. But if there's any tweaking of those hours, it would be done pursuant to that
Okay.
legislation.
Okay, sorry, that's it then.
There was
No, just, sorry, one more thing. There may be a few things that I'm just thinking about now that were not included in here, but we will include in the update. For example, I just remember that previously, if you're in an RM1 district, you could do parking at a reduced setback if you had a small lot. For some reason, that was not included in our new resiliency code. So technically, if somebody comes in right now in a small lot that is parking, they would have to seek a variance. So we're probably going to look at going back to, it's not really a change in the code, it's just going back to what it was. I don't think there was any intent to modify that. So we're also looking at instances where there may have been some inadvertent omissions from the old code to the new resiliency code.
Sidewalk cafes and sidewalk cafe concession program areas.
Oh, yeah, so that's just to change how the verbiage of how we're discussing, how we're treating those now.
And how, and can you give me a little background on that, since,
I don't have any information on that time, just a matter of just updating the verbiage. It doesn't change anything substantially in terms of the operational requirements for
Okay.
sidewalk cafe permits.
and what are the occupancy limits for the hotel occupancy, CPS 1 and MXC districts?
Yeah, if you give me a second, I can,
Thank you, sorry.
That up.
I didn't get to look at all this like you all did.
and while I'm looking this up, just to remind all the board members, let you guys know, next month, we're starting our meetings at 9 o'clock.
Oh, next month?
Yeah, starting from
Joy.
October going forward.
What's that?
Starting from next month going forward.
So October,
starting
November,
October?
and
October,
December's
November, and
canceled.
December's canceled.
Who voted for this?
Yeah, I'm with you.
So that's October 22nd,
29.
29.
It's October is the 29th.
And that's forever.
Well, it's consistent with all the other boards. It also allows the chambers to be more flexible, so we often have instances where somebody else wants to use the chambers in the afternoon, and it's hard to do that when we have the planning board start late and then go later on, so at least this allows us to finish earlier to allow, somebody else to use the facilities.
Okay.
Let me just find that section, just a second.
And November's the 26th.
Correct, after Thanksgiving.
After?
Mhm.
So I'll book.
No, before.
Before, it's 2 days before.
2 days
Is it?
before. Thanksgiving's the 28th.
I wish it was after, because I would like to see my family. Can we change that date?
Which date? The November meeting is the 26th?
Yeah.
Yes.
Yeah.
All right. You guys have any questions or comments about the discussion items? Scott, Matt, John? No? We're all good?
There's nothing controversial in here. is
No.
there?
All right, we're all good.
All right.
I'll adjourn the meeting. Tom, thanks for your special appearance.
Looking great, Tom.
Thanks, Tom.
Thank you, guys.
Reminder, our next meeting is October 9th at
10.
9 a.m.
Oh, 9, that's right. You just said that.
Sorry, I was asking questions. I just didn't see it. Probably look on.